Hey, good morning. Can you hear me? Good morning, Mr. Fleming.
Good morning, Judge.
How are you, sir?
Oh, I'm pretty good. How are you?
I'm okay, thank you.
Good, good.
We have not seen the plaintiff yet. My practice is about 15 minutes after our scheduled start time. That's one of the reasons why I waited to come out. Scheduled at 9 o'clock. If they haven't appeared by 9:15, I'll get your case called and get you on your way, sir.
Okay, fair enough. Did you receive any sort of response from the plaintiff, Judge?
No, sir.
Okay, I did not either. That's fair. You want me to just, I was gonna make a phone call, but can I mute myself and wait a few minutes? Is that-
Absolutely. Please do what else you need to do.
Okay, I'll be back in a few minutes.
Thank you.
Do you hear that?
Do I hear
Judge?
what?
Oh, I guess you don't. I'm the only one that hears. I'm hearing. Never mind.
What are you hearing?
I'm hearing. It's kind of like I'm hearing like kind of like music, kind of like little beats.
You're picking up a radio frequency in your feelings, maybe?
Unless it's just inside my head.
I thought you were maybe hearing the blowers in here. They're not loud, but they can, I wasn't sure how sensitive your microphone was.
No.
I thought Andy would get those arraignments to come through since we have a little time between now and our 9:30, where the 9:30 people maybe will come early enough for us to get going. That
Yeah.
would be ever so helpful. And Taylor, I sent that file back down and put it over to the 23rd. This is 212783GC. This is Sarah Thomas versus Trisha Alwader, David Eli Jones, and MB Moving Company. Today is the day and time set for hearing on the defense motion for summary disposition. Your appearance, sir?
Yes, Your Honor, Daniel Fleming on behalf of the defendants.
Mr. Fleming, this matter was scheduled at 9 a.m. The court has had the opportunity to review your motion in its entirety, has not received a response from the plaintiff, and the plaintiff has failed to appear as of 9:15 by this court's clock. How do you wish to proceed, sir?
Well, Your Honor, I would like to proceed. We served the plaintiff with the motion via mail and email. I've had communication with her throughout the course of this case. I have not heard from her at all since the motion was filed. I have not received a response, and she is not here today. I think at this point, the court should grant the motion because there's no legal basis for the motion in the first instance, or there's no legal basis for the claim in the first instance.
Thank you, Mr. Fleming. And as much as the plaintiff has failed to file a written response, has failed to appear this morning, court will grant the defendant's motion for summary disposition. The plaintiff's claim will be dismissed in its entirety. Mr. Fleming, did you submit a proposed order with your motion?
I did not. One question, Your Honor, and I was going to ask you about the order. And I understand the basis for your ruling. I would also like the court to rule, if possible, that the substance of the motion is such that plaintiff does not have a valid legal claim against these named defendants.
That was the basis of your motion, sir. I'm granting your motion in its entirety, not just on the defendant's failure to appear.
Got
It's
it.
based on her failure to respond to the contents of the motion.
Fair enough. Thank you. Can we submit an order by fax or email?
Email, please, sir.
Okay. Can I-
It's civil, yep. At 34th District Court -mi.org.
Okay. I will submit an
Anything
order.
else, Mr. Fleming?
Nothing, Your Honor. I'll submit an order today.
Thank you, sir. Have a
Thank
good
you,
day.
Judge.
I saw Mr. Hemmon here earlier. Did you need something, Mary Ann?
No one came in here. I don't know.
Okay.
Judge, it was just me.
Don't scare me, Andy. I said, what in the world?
My name shows up that way sometimes.
I see you talking now, so thank you for correcting that. Ma'am in the blue hoodie, would you unmute yourself and state your name for the court, please?
Allison, what's that?
Ma'am, that's not blue. It's gray, isn't it?
This is gray and then a black coat.
Okay, there's someone else in a blue hoodie that I'm trying to address. Your name, ma'am, in the
ma'am.
blue hoodie with the white letters?
Yes, ma'am. Andrea Lezak.
Thank you. And now, ma'am, with the black and gray.
Allison Lezak.
Thank you. This is 215378LT. This is Andrea Lusick versus Allison Lusick. Both of the parties are here this morning. Do the parties need an opportunity to speak? Are you ready to proceed?
I was aware that this was over because she didn't show up, so I'm not sure why I got a notice to appear.
Ma'am, you received a notice to appear because Ms. Allison Lusick filed a motion to set aside the default judgment wherein she indicated that she had not been served. The court scheduled the matter for hearing. That hearing occurred on February 1st, 2022. You failed to appear for that. The defendant's motion to set aside the default judgment was granted, so the matter was rescheduled for hearing today.
Okay.
So my question at this time is, the original case in this matter that Andrea Lusick filed was for a termination of tenancy, correct?
Yes, ma'am.
Has Allison Lucic since vacated the premises?
Yes,
Has she removed all of her property?
no,
Miss Allison Lucic, do you need to return to the premises to retrieve property, or have you surrendered your tenancy at the address?
If she's willing for me to get them, that would be fine.
Andrea Lucic,
yes, ma'am. It is fine for her to get her stuff, but nobody else is to be with her, and it's not gonna happen today. I have stuff to do today, and it has to be on my time schedule, not hers.
here's the thing, this is a termination of tenancy. And if Ms. Allison Lucic has moved from the premises, that would have resolved the matter, and we would be done today. But if you're saying that if Ms. Allison Lucic needs to get back into the property to surrender, before she surrenders the property, then we could enter a judgment that has 10 days for her to finish vacating the property. So that's why I'm asking, is there a reason for you all to speak, or how do we resolve this matter this morning?
I mean, I guess we can talk. I haven't talked to her, so her
What's
phone
a
number
good
was
day?
disconnected.
What's a good day for her to come retrieve her property?
For me, I don't know if you, obviously you don't know, I am going under cancer treatments, so my schedule is very hairy, and I also take care of my 77-year-old dad, so my schedule is very hectic. So I'd have to look at my calendar and then go from there.
Okay. Is that something you can do right now if we pass the matter for a second?
Yes, ma'am.
Okay. If you want to look at your schedule, Miss Allison Lucic, is there a lot of property that you need to retrieve? Do you know how long it would take you to get the stuff?
Maybe 20 minutes. I don't have a whole lot there.
So we're talking about maybe a 1 hour window over the course of the next 10 days.
Yes, ma'am. But somebody will have to be with me because there is a dresser. I cannot move by myself, but I could have a police officer escort with us if that would be fine.
The dresser's gone.
So she gave away my property. What else did she give away? So, you know, at the end of the day,
It wasn't your property.
Miss Andrea Lucic, that is not helpful. You're supposed to be looking at your calendar for a day in the next 10
I
days.
am
where
looking
she can
at
come
it.
Retrieve the property.
I am available on Monday, the 7th.
I don't need anything out of that house. Thank you.
Are you sure, ma'am?
Yes, ma'am.
And Miss Allison Lucic, you have voluntarily left the premises before judgment entered in this matter.
Yes, ma'am.
And you have no need or desire to return to the property for any reason.
No, ma'am. Besides my father,
Do you still have any, I'm sorry.
that's okay. My father lives with her, which she has not allowed me to see, but that's okay. If we can do something about that, that would be great.
She has never asked to see my dad.
I always ask
Well,
how he
wait a
is.
minute, wait. Before you go back and forth, this is just for a landlord-tenant matter. This family issue of not having access to your dad is not something that I could order. It's not something that this court is authorized to intervene in. But Ms. Andrea Lucic, where I'm going with this questioning is if, in fact, Allison Lucic has voluntarily left the premises, surrendered the property back to you, has indicated on the record that she does not wish to retrieve any of the property, is there any reason that we need to proceed in this matter, or could this case be dismissed?
This case can be dismissed, ma'am.
Okay. So Ms. Allison Lucic, let's again confirm that there is no property that you wish to retrieve from
Why
this
would
address.
Why
from your
would
sister's
they,
home.
why would she give away my dresser?
It's not her dresser.
When it's my turn to talk, ma'am, would you let me know?
Let's try this a different way. Would you both raise your right hands? Do you swear from the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Miss Allison Lucic, do you reside at 27557 Dupree Street?
No, I do not.
Is there any reason for you to return to the property at 27557 Dupree Street in the city of Romulus?
Apparently no longer.
Andrea Lucic, do you acknowledge that Allison Lucic has moved from the property
Yes, ma'am. After she drove with my
and
kids.
surrender possession back to you?
Yes,
And you heard Allison Lucic on the record indicate that she has no property that she wishes to retrieve from the premises.
yes, ma'am.
Okay. Ma'am, inasmuch as you have both acknowledged that the defendant no longer resides at the premises, has no reason to be back to the premises, the relief that you saw in your complaint has now been effectuated, that being the return of the property. Based on that, this court will dismiss the complaint pending in this matter. We'll note in the file that the defendant has moved from the property, has no desire to return to the property, and does not express any interest in returning to the property. That concludes the matter before this court. As I was indicating previously, if there are some other issues arising out of the tenancy or some family issues that need to be addressed, that cannot happen today for these proceedings. Summary proceedings are only about the rental, the possession of the property. Anything else in this matter?
No, ma'am.
I'm good.
I'll have the clerks prepare dismissal of this matter. Anything else, Andrea Lucic?
No, ma'am. Thank you.
Anything else, Allison Lucic?
Oh yeah, why would my things be given away?
It wasn't her dresser.
I purchased it.
No, you didn't.
Wait,
not
are you
speaking.
smoking while we're in court?
Yes, ma'am. Sorry.
Okay, okay, if you wouldn't walk in the building and do it, please don't do it while we're on video.
Okay.
Again, this complaint was just about the termination of the tenancy. If there are some things that you feel need to be addressed, that can be addressed in another proceeding. The summary proceeding is just about returning the property to the plaintiff in this matter.
And that was
Property
my
being
property
the-
that she gave.
Property being the physical space, not necessarily a shirt, a dresser, a bed.
Possessions. I got you.
That's why I asked, did you have any reason to be back in the property?
You got it.
Anything else?
No, ma'am.
Thank you. We're all set. The court will prepare the order. Have a good day.
You too, ma'am. Thank you.
Thank you. I know they're not gonna be ready. Why would they be ready? That's too much like rape. If you want to go down. Thank you. Good morning, Mr. Williams.
Yes, good morning, Your Honor.
Who brought you over this morning?
Well, Miss Thomas,
Well, thank you
And-
to Ms. Thomas for getting you over here.
yes, ma'am, thank you.
I'm not calling your case just yet. I haven't
Right.
seen Mr.
DeAndre.
Harper. I just saw
Right.
you and I knew that it was gonna be a struggle for you to get here, so I appreciate you being here.
Yes, ma'am, thank you. Yeah, I think well, I had called the courts last week. So I guess they relayed everything, and what I need to do was come in, get online, because the young lady that normally puts me online, she, well, it's a blessing for her. She started the job today.
Oh,
As of
that's
today.
wonderful for her.
Yeah, right.
And I didn't
right.
want you to have to pay somebody to get online again. I was not happy about that the last time.
Yeah, yes, ma'am. Yes. Yeah.
So
but,
just wait, the case is
mhm.
scheduled at 10 o'clock.
Yes,
If
ma'am.
Mr. Harper's not here by 10:15, we'll proceed, okay?
Okay, that would be fine, Your Honor.
Thank you, sir. Ms. Samples?
Yes, Your Honor.
Ah. It's still early. I haven't seen anybody from Mr. Levine's office as of yet. Good morning, Ms. Flagg. Uh-oh.
Really just say thank you. Thank you for anything.
Mary Ann, I have the first files from Romulus. Miss Greer is our MIDC, so we see them pop on, we'll get them taken care of.
Okay,
Good morning, Miss Swistek.
Good morning.
How are you, ma'am?
I am good. And you?
I am wonderful, thank you.
Good.
You're here for the 9:30 West Village matter?
That is correct.
My practice is about 15 minutes past the scheduled time, so if the West Parker tenants are not here by 9:45, we'll get your case called and get you on your way, okay?
Perfect. See you at
Thank you.
10:15. Thank you.
And did they already tell you that the other case had been adjourned? The 9:15 has been adjourned out?
Yes,
Okay, thank you, ma'am.
thank you.
Mr. Truba,
Good morning, Your Honor.
good morning, sir. How are you?
Good, good.
Would you like to speak to Ms. Flagg before your case is called?
Judge, I'm always up for speaking to people.
Ms. Flagg, you're going to see an invitation to join the attorney in the breakout room. Please go there and discuss the case with him. When you come out, the court will call the case and hear your objection, okay? Thank you, ma'am. Good morning, Mr. Parker.
Good morning.
How are you,
I
sir?
don't know what the hell I'm doing.
I'm doing okay.
The attorney for West Village is here.
No, I probably won't
This is a
hear
non,
anything about it before I leave.
Mary Ann,
Oh. Yes.
I
Sorry,
can hear you.
I'm sorry.
That's okay. I just wanted you to know before you said something else. Sir, the attorney is here from West Village. Ms.
Yes.
Swistek, do you need to speak to Mr. Parker before this matter is called? Ma'am, you're muted if you're talking to.
I'm sorry, Your Honor.
My question was, would you like to speak to Mr. Parker before this matter is called?
Yes, if you can put us into a breakout room, that would be great.
Mary Ann, I'll get you moved into a breakout room.
Your Honor, can you also put Miss Samples into a breakout room?
Absolutely.
Thank you.
Thank you, Officer Ramsey.
Your Honor, we are back.
Mr. Parker is not.
Ooh, maybe he lost his way.
No, he's just still in the breakout room. It's okay.
Okay.
Marianne will get him out. This is 214734 LT. This is West Village Estates versus Valerie West and Brandon Parker. May I have your appearances, please?
I'm Janet Swistek, appearing on behalf of West Village Estates.
Mr. Parker, state your name for me, please.
Brandon Parker.
Thank you. Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay. The parties were last here on February 1st, 2022. Mr. Parker did appear at that time, but he left before the case could be called. The court adjourned the matter to today. The parties have had an opportunity to speak. Ms. Swistek, how are we proceeding this morning?
We have reached an agreement and a consent judgment will be entered as to Mr. Brandon Parker, a default judgment as to Valerie West. The terms are he brought into the community office money orders totaling $1,000, brought it in this morning. So we have applied that and it leaves a balance owed of rent in the amount of $1,822.67. We're also asking for court costs of $199.06, which includes the statutory attorney fee. The redemptive amount is $2,021.73. Mr. Parker has heard from Sarah, and they will be mailing him an additional sum of $1,200. It will get mailed to Mr. Parker, not to West Village. He anticipates that he will be able to pay the entire rent balance, including the portion that Sarah funding is not going to cover, by March 13th, 2022. So I have changed the writ date to then, actually, I just noticed March 13th is a Sunday, so I'm going to change it to the 14th for the writ date. And he will, by that date, between money he will receive from Sarah and his own funds, pay $2,021.73, which will bring him current through March.
Mr. Parker, were you able to hear Ms. Swistek just now?
Yes.
And is your agreement and understanding that you owe a total rent of past due rent of $1,822.67?
Yes. I know
That
what
sounds like
including fee. Well, I mean, like I know they add fees and stuff like that. So I mean, like I'm guessing with court costs and stuff, I'm sure that's probably the total amount.
The court cost is $199.06 for a total of $2,021.73.
Okay.
Okay, you agree that that's the amount that's due and owing?
Yes. Like I can't get online to see what my current amount was. And I mean, like I haven't got anything in the mail that says the amount total. So, I mean, I'm assuming that's the correct amount, and I'm gonna make sure it's done by the 14th.
The reason I'm asking is that Ms. Swistak came out of the breakout room and indicated that the parties had reached a consent. A consent judgment means this is the amount that you're agreeing to.
Yes, I'm agreeing to that.
Okay, and in as much as your landlord is being represented by an attorney and you're not represented, your agreement that this is the amount that's due and owing would not become final and enforceable for 3 days. Do you understand that as well?
Yes,
You have until March 14th to pay the amount that's due and owing in full or move from the property. Do you understand that?
yes.
Now, Ms. Swistak, is Mr. Parker going to come in to the office and sign the consent, or are you doing it by email, or how are we doing that?
Right now, I would ask if I have his permission to simply sign his name on the judgment, and then I can email it into the court. Would that be adequate?
Mr. Parker?
Yes, that's fine.
Okay.
So, Mr. Parker, Ms. Swistak will present a consent judgment to the court, total due and owing rent and cost $2,021.73 with a writ date of March 14th, 2022. You on the record have indicated that she has permission to sign your name to that consent judgment. She will sign it, email it over to the court. I'll sign it. You'll get a copy in the mail. Okay?
Okay.
And Your Honor, what is the email address that I should use?
Civil@34th District Court -mi.org. Anything
very
else on
much.
behalf of West Village?
Pardon?
I say anything else on behalf of West Village?
No, that is it for this morning. Thank you.
Anything else, Mr. Parker?
No, that is it.
Thank you, Mr. Parker. You have a wonderful day, sir.
Thank you. You too.
Thank you. Good to see you, Ms. Swistak.
Thank you. Have a good day. Bye-bye.
You too. Marianne, I'm stepping off, but if Mr. Chuba comes, let me know and I'll come right back out.
Okay.
So the judge, she's here in the courtroom, right? She's upstairs in the courtroom.
Yes, she is.
That guy, he's pretty nice. Well, I hold it. I'm paid.
Sometimes if you know you're wrong, you might as well. And what I want to do is make sure your position, with the. Well. Okay, you're good. As long as you have your hat on, you look professional. You're good.
Okay, thank you.
Is that your neighbor that you have bring you?
No, she's my caregiver.
Okay.
Mhm.
You live by yourself? Okay.
We live together.
Okay, I was wondering if you were by yourself. They don't, do things around the house.
Yeah. Well, I do a lot of the cleaning. She does the cooking, the washing the
Okay.
clothes and stuff.
Oh, good.
I try, we try to share.
Absolutely.
Because,
Good.
I know how to do a lot of things.
Uh-huh. That's good.
I do my room, she do her room.
It's just two of you guys that live there?
Mhm.
Okay.
Yeah. And we're really trying to get up out of there.
What city do you live in?
We live in Belleville.
Okay.
And I've Our bedrooms are on the second floor.
Oh, goodness, how you getting upstairs?
I get up there, but it's.
It's a struggle.
Yeah,
That's
it's
sad.
starting to get a struggle. We've been there 3 years, been trying to get out of there for last year or something.
Are you like in an apartment or something? Or?
It's a town, it's like an apartment townhouse.
Okay.
Mm. You know, and what was it, just about a good month or so? Somebody knocked on the door and I was sleeping. I got up and I went run, call myself, jumping up out the bed and stuff. And I was still disoriented.
Oh.
And I went to reach, for the wall as I touched to know where I'm at. I went straight down the stairs.
No, you did not.
Head first.
Oh my goodness. Mr. Williams.
Went down there like Superman without a cape.
Oh.
Mhm.
And what time of night is this? Somebody knocking
This
on
was
the
in the
door?
day. This was in the
Oh,
day.
good. No, you
And
don't
really,
need to be upstairs.
really what it was sometime.
Are there parties ready on Midland versus Flagg?
We are, Your Honor. Thank you.
This is 197724 GC. This is Midland Funding versus Courtney Flagg. May I have your appearances, please?
Good morning, Your Honor. Brian Truba, appearing on behalf of plaintiff Midland Funding. My P number is 61752.
Ma'am, would you state your name for me, please? Ms. Flagg?
Judge, this might be difficult. She was having some technical issues when we were in the breakout room. She was coming in and out and.
Ms. Flagg, are you able to hear me?
Hello,
Yes, ma'am. Would you state your name
Hi.
for me, please?
Courtney Flagg.
Ms. Flagg, today is a day and time set for the hearing on your objection to the tax garnishment in this matter. You've had an opportunity to speak to Mr. Truba this morning.
Yes,
Do you have a resolution of this matter?
We do not, Your Honor.
Ms. Flagg, it's your objection. What do you want to tell the court this morning?
so I can't see understanding that I guess they have two offices and I guess both offices garnish me for separate wages. But I guess like the one for his office was supposed to be 1,900, but they only like went after 1,200 of it, which to me, like I understand like I still owe the $700, but I just feel like it's not fair to me that because they had a mistake on their end, that they're not going to come for the 700 out of my taxes.
Okay, Ms. Flagg, you've lost me. You said they have two offices. This is a tax garnishment, and you filed an objection indicating that this judgment has been paid. Plaintiff's office filed a response that listed in accounting that shows that $725 remains due and owing.
Yes. So apparently, Midland Funding has two offices, and I was garnished by each office, not just the one. So I didn't know that like I still owed for part of the money for his office because like they filed for 19, but only took 1,200.
I'm sorry for.
They filed a garnishment for $1,900, but your tax return was only $1,200.
No. So they filed a garnishment for 1,900 for my wages, but only took 1,200 of it. I wasn't aware of that because I had another garnishment from Midland Funding, I guess from another office for another $600. So I thought it was all one.
Mr. Truba?
I can clarify, Your Honor. Apparently what happened was our office issued a wage garnishment. This was a 2-count complaint. The defendant was sued on a pink account for $1,070 and a Forever 21 account for $704. When our computer system generated the garnishment, it only pulled, because of a programming error, Your Honor, it only pulled the numbers for count 1 and the pro rata costs that were associated with that account. So the wage garnishment where it said judgment amount was for about $1,200, is what the computer erroneously said. The judgment entered in this matter was for $1,900. So the employer pulled her wage garnishment until it hit the $1,203 and stopped. Apparently, there was another law office, or the defendant has a judgment with another law office. And if you look at her exhibits, you can see there's a garnishment for $639, and it was being paid to a law office in Warren. So that was the other, it's a different case number, Your Honor. That case number was for 191546 GC. It was a different garnishment. Long story short, what happened was, Your Honor, we pulled a wage garnishment for $1,200 and then the garnishment stopped. The judgment's not paid, but she did pay $1,200. So we still have an outstanding balance of $725.67. So we issued a tax garnishment, and that's what she's objecting to today.
Ms. Flagg, are you saying that these two cases are the same case?
No,
Or are you?
I thought they were the same case because it's the same company. It's Midland Funding, but I guess they're two different offices. And I didn't know because the numbers added up. When I added up the numbers for the two garnishments, that's why I thought it was one case.
But you now understand that they're two separate cases?
Yes, but the thing is still, like, I don't feel like my income tax should be penalized because their computer made an error. Like, I don't mind making payments on it, but I don't feel that my income tax should be garnished because their office made the mistake of not doing the full garnishment at once.
Okay, Ms. Flagg, the issue is that your objection to the garnishment indicates that the judgment's paid, but you're now saying that you understand that it's not paid.
Yeah.
Okay, well, Ms. Flagg, in as much as you acknowledge that the judgment is not paid, the court is required to deny your objection.
It's not paid in full for that office.
You broke up there for a second, ma'am. What were you saying?
I didn't say anything else.
Okay, what I was saying is that because you filed an objection to garnishment that alleges that the judgment has been paid when it has not been paid in full, the court will find your objections to the garnishment invalid and order the state to release any withheld funds to plaintiff. If you owe money beyond that which the tax garnishment pays, you can make arrangements with the plaintiff's office to pay the balance, or you can file a motion for installment payments with the civil department here.
Okay.
Anything else, Mr. Truba?
All set, Your Honor. It's always a pleasure. Thank you.
Anything else, Ms. Flagg?
No, that's it.
We're all set. Have a good day. I will mark the order on the objection to garnishment in the file, and we'll get it out in the mail to you. You both have a wonderful day.
You too, Your Honor. Thank you.
Thank you.
They moved down and talked to Sandy. And Sandy.
Oh, that's fine.
It's a live one.
That's fine.
Okay. You want me to have him come sit here? Or?
Oh, it's a car accident. Okay. Yeah, if they're both here and they're ready, because I'm
I think just one side.
okay. If you want to leave them out in the hallway in case, and if you want to come in here, I don't care. If you want to just have them out in the hallway until
The other
like
side
15
gets
minutes after scheduled start time. The other side's not here by 10:15.
here.
Okay.
Oh, then I'll bring it in.
Thank you. I'd appreciate that. So Mary Ann, we have a live hearing.
Oh, okay.
That's what
Which-
Officer Brooks was just in here trying to get us. It's a small claims at 10 o'clock.
Okay.
It's fine. I just want to get these other things resolved if we can. Ma'am with the pink sweater,
Yes, ma'am.
your name, please?
It's Albertina Evans. I'm using my parents' computer.
Miss Evans, your case is scheduled at 10 o'clock.
Yes,
I
ma'am.
have not seen Mr. Robinson as of yet. So if you'd sit tight, if he's not here by 10:15, I'll get your case called and get you on your way, okay?
Okay, thank you.
Thank you. Thank you for getting Romulus in with Ms. Greer, Mary Ann.
You're welcome.
Ah, here's Mr. Robinson. Good morning, Mr. Robinson.
Okay.
Morning, Judge.
Ms. Evans is here. Would it be beneficial for the parties to speak before the case is called?
Yes, Judge, is my client on?
Yeah, I'm here.
Oh, no,
Terry, I don't see her.
oh, my client's supposed to be joining on shortly, Judge, if you could just pass on
Wait a
this.
little while. Absolutely.
Thank you.
Judge, this person who's coming in is our translator or an interpreter.
Our interpreter for Romulus.
Correct.
Yep.
Good morning, sir. How are you?
Good morning. I'm trying to get my picture. Can you hear me?
Your picture was up. You were fine. Yep, you're perfect.
It's coming now. Yeah. Can you hear me now?
I can hear you perfectly, sir.
Thank you.
The City of Romulus Police Department is on. They're in a breakout room with someone else right now. I do not have the file for the case that you're here for, but I'm sure somebody will get it upstairs to me.
Okay.
Good morning, ladies. Are these both sides? Okay. No, they're gonna stay back in the audience for just a second. We have a 10 o'clock arraignment that has an interpreter, and I don't want to keep him any longer than we have to. Thank you so very much. Yep. I don't know, Mary Ann, are you going to come in here and do it, or you're just happy to record it on the Zoom that's running?
Whatever you want me to do, I think.
Whatever I
As long
want,
as
it's
it's
not about what I want. What are you talking about?
Yeah, I mean, I think it's fine if, as long as it's on Zoom, I can get it.
Okay. No, I'm keeping these.
Oh.
Are you gonna take the files from me? You're just gonna rip them from my hands? Is that what we're
I thought
doing
you were
now?
gonna hand it to me.
Mr. Harper? So when you look and you see 10 people and nothing's really go, that's never a good sign. This audio's not connected. I think the other part of my 10 o'clock case, this audio's not connected. And I always hope that if I put somebody out and bring them back in, it'll make them think something else. Oh. Good morning, sir. In the Public Works jacket, your name, please.
DeAndre Harper.
Mr. Harper, how are you today?
I'm well. How are you, ma'am?
I'm well, thank you. This is 214360 SC. Ooh, excuse me. This is Richard Williams versus DeAndre Harper. Mr. Harper, this is your motion to set aside default judgment.
Yes, ma'am.
Please proceed, sir.
The reason I want to set aside because my phone was off at the time. I ain't had the money to pay my phone bill, and you know the case that my uncle's trying to sue me over is not. Because I don't feel that it's right. Because at the end of the day, we had a agreement. He said he was trying to get rid of that truck. I bought the truck from him. He took the plow off of it and took it over to my cousin Aaron's house, which is still there. And he sold me the truck, went to the Secretary of State and everything with me.
Was that it, sir?
Yes, ma'am. I mean, like I said, I don't think this is right for him to try to sue me with a truck with plow when I never had no plow on it at all. It was just a regular truck.
Mr. Williams, is someone down there in the room with him? He's muted. She's in there, yeah.
Yes, Your Honor. Can you hear me?
I can hear you now, Mr. Williams. Were you able to hear Mr. Harper?
Yes, I did, Your Honor.
And what is it that you wanted to say in response, sir?
In response to that was, as I gave a sworn statement prior, a couple of times before, DeAndre consistently kept begging me to buy my truck. And I consistently told him no. I said no. I told him no for about a good month or so. He said, Uncle, you would really be helping me out if you let me buy this truck from you. I have to get back and forth to work. So I said, okay.
Why would I say that when I got a car already?
No, Mr. Harper, that's not how we do things here.
Okay,
Mr. Williams finished
I
speaking.
apologize. I apologize. I'm sorry.
Your Honor, and with that being said, I say, well, DeAndre, if I sell you my truck, the plow and the motor has to come with it because it would cost me too much money to remove everything, the harnesses and everything, the remote control up and down, left and right. It would cost me too much for that. Okay, so I said, well, what do I gave him my price. I told him I wanted $4,700 for it. So he said, okay, fine. I said, okay, well, what do you have on it? He said, I have $700. And then he came over and he gave me the $7. Okay, we went over to my nephew Aaron's house to remove the plow because for the reason of that plow is there and it's available to him. And he knows that. Okay, but at any rate, the plow was taken off. It was the end of the winter. The end of the winter. Everybody that does plowing in the winter, they start putting the blades on around about October, November. They take them off by March, the first part of April, because there is no use for them. So he had nowhere to put it at. He had nowhere safely to put the blade. So with all this being said, DeAndre just doesn't want to pay me for my truck. He just doesn't want to pay me for my truck. And it's sad. He begged me, and I trusted him like a loving uncle is or supposed to do. But he just screwed me over. And he continued to want to screw me over. But also at that same token, Your Honor, I did apply for just to get my truck back. I have no problem with that. I'd rather have my truck back than to chase him down about this money. Just give me my truck back. Your Honor, I filed the paperwork for it.
Anything else, Mr. Williams?
No, Your Honor.
Anything else, Mr. Harper?
Yes, I want to add. When he had called me to come and get this truck, this is how
Are
we
you
end
laying
up.
down, sir?
No, ma'am, I'm sitting up.
Okay.
I'm just on the floor because my charger, I'm close to the charger to
Your
the wall.
charger
Ma'am.
cord is short? Yes,
Yeah.
sir.
But anyway, like I was saying, ma'am, due to the prior, when he called me and told me he needed help because the guy wanted that truck away from the other guy, he had the truck. So in that process of that truck on the ride home, he told me, he says, DeAndre, I feel like giving up on this thing. And I told him, I said, well, I'll take the truck off your hand if you feel like giving up on this thing. Then once I purchased the truck and gave him that, we went down to the Secretary of State. He went with me, hand in hand, to the Secretary of State to sign the title over. And after that, the truck had problems. So that's my responsibility because I bought the truck. I put it in the shop. It costed me over $2,000 to get that back. True, he did ask me to get that truck back. I told him, I said, yes, you can have that truck back, but it's not going to cost you what I paid for it. It's going to cost you the amount for the to fix it, the amount that I paid to fix it. I'm sorry, the amount that I paid to fix it. And, you can have it back. You pay that. He said, well, this is what I'm going to do. Get loud with me and start fussing at me.
Mr.
Then
Harper?
Yes, ma'am.
Did you pay Mr. Williams all the money that you promised to pay him?
Yes, I did. Yes, I did. What we agreed to, that verbal agreement, yes, I did. Other than that, he wouldn't sign that title over to me, ma'am. And then on top of that, when we took that blade off of there, he says truck with blade on there. He just said himself, he took it off. So how is he going to sue me for something?
You paid Mr. Williams $4,000?
He did not agree no $4,000. There was no $4,000. It was not agreed for that. For $4,000, ma'am, I could have went to a Ford or used thing to get a whole nother truck, then to pay $4,000 for a 91. Why would I do that? That's rusted out with transmission issues. That's going out backwards, man. I'm just being honest. I'm
Mr.
sorry.
Har-
I don't mean to be loud. Excuse my tone if I'm being loud or anything. I'm just trying to say it so you can hear me. And
No,
then,
Mr. Harper, I can hear you. Here's the issue. This is a
yes, ma'am.
small claims case.
Yes,
Mr.
ma'am.
Williams filed a complaint that you owe $4,000 for this truck. This
Yes,
matter was
ma'am.
scheduled for hearing, and Mr. Williams was able to get connected. Your motion to explain why you failed to appear says that your phone was off, but this is court. You knew you had court. If your phone is off and you can't Zoom in, you have to make arrangements. This court has a Zoom courtroom where you can come.
I apologize, ma'am. I'm sorry. I apologize.
No, you can come to the courthouse and they'll put you in a room and you can connect.
Well, I
Or
didn't-
you can find some other way to connect. If it's important enough for you,
Yes, ma'am.
you find a way to do it. You were supposed to be here on the 18th. You weren't here. The court finds that your indication that your phone was off is not good cause for your failure to appear.
I didn't understand.
Your motion also did not include a meritorious offense. I asked you, had you paid Mr. Williams the $4,000, and you said it was never the agreement. The complaint in this matter that Mr. Williams filed back, quite some time ago now, October 6, 2021, clearly provides that he's claiming $4,000 for the purchase of a 2002 Ford F-150. He indicates that you paid $500 in cash. You knew what the allegation had been. You failed to produce any proof or attach any proof to your motion that you had a meritorious defense in this claim. This court's going to find that your motion to set aside default judgment fails on both parts.
Okay, can I say
Your
one?
motion is going to be denied its entirety. The request for seizure that Mr. Williams filed previously, the court will sign.
Okay, could I require one thing? Could I say one thing?
Absolutely.
On paper, he just said $500. Now he just said 700. Which one is it?
It's what he put in writing and filed with the court back in October, sir.
So okay. So how long do I have to pay him this money?
There's a judgment against you right now for $4,120.
Okay, how long do I have to pay that? Because I don't want to have 400,000 to no $4,000. He know that.
You can make an arrangement with Mr. Williams, or you can file a motion for installment payments with the court.
Well, I would like to file. I'd like to file that.
Then you come and file it, sir.
How do I
The
file
civil
it?
clerk
Where
will
at?
help you when you come.
Okay. It's bullshit,
Anything
man.
else, Mr. Harper?
No.
Anything else, Mr. Williams?
Your Honor, I would love to have my truck back. I just don't want to
No,
deal
I'm
with
gonna
it anymore.
back. I'm gonna pay him back. I'm gonna pay him back. He ain't getting nothing. I'm paying it back. It's the title of my name. I'm paying it back.
All right, thank you. I appreciate it.
Man,
Thank
don't
you,
thank
Mr.
me.
Williams. Have a good
You
day.
always
Mr.
get me
Harper,
some
have a good
bullshit.
day.
You always got me in some
Oh,
bullshit.
you're not cursing on the record. No. That's not what we do.
No, this ain't the second time he
Absolutely
got me in
not.
court. He tried to get me locked up and everything. He tried to get me locked up and everything for some false stuff. He didn't show up on court talking about I did something to him. This man is causing trouble to me. He causing me to pay money. He's threatening me. He's threatening my life. But y'all see there's a disability for this man and feeling sorry for him. Y'all don't fail to realize I'm not the only
Mr.
one who
Harper?
go through this.
Mr.
This
Harper,
is not right
understand
for
the
me,
court
man.
doesn't feel sorry for anyone.
This
When
is
you
not
get
right.
receive a
This is
notice to
not right.
appear in
Yes, y'all
court,
are.
you find a way to get to court.
Yeah, I
I'm not
will.
gonna
I
argue with
will.
you about that
I
point.
will. And I'm getting me
Okay.
another lawyer because it ain't over with. I'm gonna file all the motions I can file.
Thank
Have
you,
a
sir.
blessed
Have a
day.
good day. Mr. Robinson.
Me?
No, Mr. Williams, you're all set, sir. Have a good day. I'm calling Mr. Attorney Steve Robinson.
Again, good morning, Your Honor. I see my client is on and I see, I believe it's Ms. Evans.
Evan,
Yes,
you
it
all
is.
three need to go into the breakout.
Yes, Your Honor, if we could.
Marianne, I'll move you into the breakout.
Thank you, Judge.
I know that you all are here for trial. I'm waiting for a criminal case that involves an interpreter, so I don't want you to start and then have to stop. So you just give me a moment to see if Romulus will get on with the interpreter and the defendant will get that done and get you on your way. I say that ever so optimistic. And we have to switch over from Christmas to St. Patrick's Day. I just skipped completely over Valentine's Day back there. Oh, Yep, Romulus, the interpreter, is in with Miss Greer. Wonderful. I'm stepping off for half a second, but I won't be gone long. Okay, thanks. It's only Tuesday. I'm not complaining, it's just Tuesday. And I'm ever hopeful. No, I think because they have an interpreter that it's gonna wind up being a thing. No, it's on Zoom. I know. But they're all in the breakout room, the defendant, the interpreter, Miss Greer, so I'm hoping that would help them kind of move through it. Anything else going on in the building? Okay. Look at the strike team is here. No, I don't like that one.
Oh.
I already have this one marked up with the stuff on. I just haven't thrown that one away. I keep looking at it. That is December. Have the parties had an opportunity to speak? Have you had an opportunity to speak to one another? Okay, and you were unable to resolve it? Is that correct, sir? Okay. I already know what's gonna happen as soon as I call the case.
Why is it streaming live on YouTube?
It's a court docket. The docket's online. Watch.
Mm-mm. Mr. Robinson, when he comes out, I'll call his 2 cases. And
Court
whatever
docket's live everywhere.
happens. Are we ready on Evans, Mr. Robinson?
We are, Your Honor.
This is 214741 LT. This is Brookdale Farms versus Albertina Evans. May I have your appearances, please?
Good morning, Your Honor. For the record, Steve Robinson, appearing on behalf of Brookdale Farms.
Ma'am, state your name for me, please.
Albertina Evans.
Thank you. Today is the day and time set for plaintiff hearing on plaintiff's request to lift the administrative stay that went into place on November 10th, 2021. That stay was to be in place for 45 days. 111 days have now passed. What's the status of this matter, Mr. Robinson?
Your Honor, I believe we have resolution on this. As the court indicated, there was a Sarah stay. I've spoken with Ms. Evans. They're actually in the process of vacating and are going to be leaving in the next few days. I did tell her that there's a statutory 10-day period. It appears that she also has an email from Sarah that something is lost in transit and they couldn't deliver it to her mailbox. But for whatever reason, Judge, I think we've got an agreement that we can enter a consent judgment for possession on the amount due and owing. I explained to Ms. Evans that this is not a money judgment. It's just the money she has to pay if she wants to stay. And I believe she understands that, Judge.
And what is the money what's the rent that's due and owing, sir?
Judge, it's $7,852 and court costs of $164 for a total of $8,016.
Ms. Evans, were you able to hear Mr. Robinson just now?
Yes, ma'am.
Have you received a response from Wayne Metro regarding your Sarah application?
I received the first one, the Miss Marquita Banks is her name. Sent me an email saying that they were having accounting support issues, so that they were getting it fixed. And then I got an email from her on the 20th saying that they had printed out the check and sent it, and that I should wait 2 weeks to receive it. Now, the issue is with receiving it from the address. I have to go to the post office because the mail guy can't get into the back of the mailbox to put mail in there because he said that there's a fake door on there, and that our landowner had told him that our mailbox was taken off because
Sir, is it possible for you to step away with the child so I can hear Ms. Evans, please?
He's with.
There's no child in here. They're in the.
Or is there somebody? Okay, sorry about that.
I'm sorry.
Thank you. Okay. The landlord
mail,
with the fake door.
Yeah, and the mail guy had told us that the landowner had told him that he could forward our mail to her address. Well, he said that he couldn't do that, so he took our mail up to the post office, and the lady said that we were supposed to pick it up yesterday before 3 o'clock, but we were moving everything out of the trailer, so I couldn't even get up there. I plan on going up there today, hopefully after my son's doctor's appointment, to get everything, and I'm hoping it's there so that way I can give her money.
So Wayne Metro has mailed you a check to pay your rent, but you're moving out?
Yeah, we plan on moving out already, but we were waiting at the house for the mail to come in so we could give her check. But when they told us it was going to be another 2 weeks, we decided to just move out now. That way it wouldn't be a whole nother month that we have to owe her.
Okay. Did you hear Mr. Robinson no. Did you hear Mr. Robinson indicate that rent is due in the amount of $7,852?
Yes, ma'am.
Is that amount accurate?
I don't know. We don't get bills from her.
So we don't know.
But you know how much your rent is each month, and you know the last time you paid.
At first it was $295, and then it went up to, I guess, $350 without notice. So I don't know.
$315. Because you had
went up to $315. I don't know when
my brother was not staying with us. Just because he was there to watch my son, that's not meaning he stays there.
Ma'am, my question to you, no. See, this is the thing. I understand that you're at home and you just shout out, but that's not what we do. You wouldn't do it if you were standing here in court. I am very specifically asking Ms. Evans, does she agree that $7,852 is doing rent? Or you're
Yes, ma'am.
saying
I don't feel like that's right. but we're
that
not
is an accurate amount?
I would guess so. I mean, I'm not specific.
So we're not arguing with about what the amount is. We're just trying to get it paid off so we don't have to deal with it anymore.
Sir, same thing. I can hear a little bit of what you're saying, but not enough to understand what you're
No,
saying.
I was saying that I don't know.
And
What I was saying was I don't know if that's the exact amount, but we're not arguing over the specifics. We're just trying to get her paid so we don't have to deal with this situation.
I understand and I hear you, but this is where I am. It's a non-payment of rent case. And Mr. Robinson says you have an agreement. An agreement means that the parties say that this is what it is. And if Mr. Robinson says Mr. Robinson says 7,852, and I ask you and you're not sure, well, I need you to be sure, because my next statement would be, the plaintiff is also asking for a cost of $164. So the total owing would be $8,016. And then Mr. Robinson would say, that's what the parties agreed to. They'll have it paid or moved by a certain date. And if you get the check from Wayne Metro and you apply it towards the rent, and you all work it out a different way, that's fine. But if there's an agreement, I want to be sure what the terms of the agreement are. That's all I'm trying to get from you this morning, if that makes sense.
And Your Honor, what we're saying is that whatever they say.
That's what we're agreeing to.
Is what we're agreeing to, because every time we turn around, our rent either goes up or we're charged for something else or in general.
Your Honor, if with all due respect, I have no idea who the gentleman to the left is, and unless he's counsel, he's not a party to this matter.
Actually, he is. He's also on the trailer.
I don't know if he's in all other occupants, and in as much as plaintiff did not attach a copy of the lease, I don't know who's a lease signer to the property.
So we can move on, Judge.
No, we can linger here, Mr. Robinson. Absolutely.
Please, because I would love to demonstrate everything she's done.
No, ma'am. See, this is the thing. This is not how this happens. Non-payment of rent case. They file a complaint that says you owe $5,500. The parties come for the first hearing, SARA application. SARA application means automatic stay. Stays in place pursuant to an administrative order put forth by the state. 45 days past, plaintiff hasn't been paid in full. They asked the court to lift the administrative stay. That's why we're here this morning. But before I enter a judgment against you and all other occupants, whoever they might be, I want to inquire a little bit as to the status of the SARA. And you're telling me this problem with the mailbox. And if you have a problem with the mailbox, that's something that you take up with the landlord. But if you're going to pick up a check and pay the check and we move forward from there, that's between the parties.
Okay, I also had a question, Your Honor.
Absolutely.
Where do we go to file certain places for falsified documents?
You're asking me a question without really asking it. So I'm not sure
well,
what falsified documents.
We had a water bill for $900 when we weren't even there for that month. We were in Florida. So 900 of what we owe her is a falsified document. Yes.
Yeah, my brother lives.
But we were in Florida.
I'm the
So
husband.
you don't have an agreement, Mr. Robinson.
I'm sorry, what, Judge?
I said, do you not have an agreement?
I thought we did when we were in the breakout room, Judge. I went over everything.
You didn't ask about agreement. You asked about the SARA program and if I could email you the email.
Judge, excuse me, sir. Judge, I would not represent to this court that I thought we had an agreement when Ms. Evans is now saying that we didn't. I thought I went through this thoroughly with her. And I thought she understood. I
understood about emailing you the SARA email.
No, ma'am, same rules apply. We don't interrupt people. Please don't do that again. If you don't have an agreement, I have a trial sitting here physically in the courtroom. I have an interpreter waiting for a 10 o'clock case. I have Mr. Morton now on. If the parties have an agreement, great, I'll take it, sign it, we'll get on our way. If we need to have a hearing, we'll have a hearing.
Okay.
So do you want to go back into the breakout room or do you have an agreement, Mr. Robinson?
We have an agreement. I'm over it.
I'm sorry.
We have an agreement.
Okay. I don't know what to say, Judge.
The agreement is, as Mr. Robinson indicated, that you owe $8,016, that's $7,852 in rent, $164 in cost.
Yes.
And you'll pay this amount or vacate within the 10 days provided by statute?
Yes, Your Honor.
And how are we going to execute this consent? Were you going to meet to sign it, or are you going to authorize Mr. Robinson to sign it on your behalf?
He, yeah, he said, you said have him sign it, or if we sign it, I'm sorry.
Because we're virtual, you are not going to be able to physically sign it right this second. So are you going to authorize Mr. Robinson to sign that this is the amount in court costs
Yes.
and rent? Or, okay. And ma'am, inasmuch as Mr. Robinson represents your landlord and you are unrepresented, that judgment will not be enforceable for 3 days. He'll affix your signature to it. He'll email it to the court. I'll sign it. You'll get a copy in the mail, okay?
Yes, ma'am.
Mr. Robinson, you were poised to say something.
I was just going to say thank you, Judge, and I was going to wish Ms. Evans the best. That's it.
And Ms. Evans, if you get the rent that's due and owing and you surrender it to your landlord and you
Yes,
satisfy
ma'am.
the judgment, okay, that's the thing. It's a pay or move. Anything else, Mr. Robinson, in this matter?
No, Your Honor.
Anything else, Ms. Evans?
No, Your Honor.
Thank you. We're all set. Ms. Evans, good luck to you. Have a good day. Mr. Robinson, you have another matter. You have 214740 LT. This is Brookdale Farms versus Adarius Carr. This matter was scheduled at 10 o'clock. It's now 10:33 by the court's clock. Is there a Adarius Carr? Ms. Cooper was here for the defendant the last time, that last time being November 17, 2021, in which time a Sarah stay went into place. I have not seen Ms. Cooper this morning.
Your Honor, if I recall, Ms. Cooper, for lack of a better term, kind of jumped in to help us clarify an issue as to Sarah eligibility. The court may or may not remember that there was another person living there. So I think she assisted the court in determining the eligibility issue there. I don't think it was I think it was a limited appearance, Judge.
I made the notation that she was here for the defendant, and I thought it was that he had moved and his a roommate was left behind and he had made an application for Sarah. But in any event, he's not here. There is no one here from that property. That stay went into place. And we are now 104 days since entry of the stay. This court has received information that the Sarah application was denied for the tenant being unresponsive. Mr. Robinson, how do you wish to proceed this morning?
Your Honor, we're requesting, excuse me, a default judgment, total rent doing $1,476. Your Honor, I have to do my math on this. I believe it's 1,312 and then 164 in court costs. Writ to issue 3/14/22.
Inasmuch as this case was scheduled at 10 o'clock, it's now 10:35 by the court's clock. Defendant having failed to appear, Sarah stay is lifted. Default judgment will enter in favor of plaintiff and against defendant with rent to retain possession of $1,312, court cost of $164 for a total judgment of $1,476. Plaintiff's office to submit. Anything else in this matter, Mr. Robinson?
Oh, Judge, thank you.
Thank you so very much, sir.
Thank
Have a
you.
good day.
I'll see you, Terry. I'm going to submit that paperwork today. So,
Okay, thank you.
Sir.
see ya.
Mr. Morton, how are you?
Morning,
sir?
Your Honor. Morning.
I have a 10 o'clock trial that I'm going to start. So I see you're here for 10:30. I have not seen Wilder or Orvis or Volkman. So give me, let me see how much of the small claims trial I can get through.
If I may just give you direction on one case, Your Honor.
I'm sorry?
I can just give you direction on one of the cases, Your Honor. We're going to withdraw our motion for Volkman and Orvis. They came in and paid off the previous judgment. So we're not going to move forward on that one. So the only one left is Wilder.
213917 LT Country Metals versus Corey Volkman. Mr. Morton, you're indicating that you're withdrawing the motion for issuance of an order of eviction?
Yes, we are, Your Honor.
Thank you, sir. Sit tight. I'll get back to you momentarily.
Absolutely.
Thank you. Parties ready? This is 212571 SC. This is, it's listed as Radab Camellia versus Sherilyn Freeman. Would you state your names for me, please, sir? State your name. And ma'am. Thank you. Sir, this is a small claims case that you initiated on February 8th, 2022. You filed an affidavit and claim indicating that Ms. Freeman owes you $6,500 for car damage, front bumper, right corner fender, front headlight, gear sensor, washer fluid. You attached a copy of the police report along with an estimate for repairs
Yes,
and some photographs.
yes.
Ma'am, have you filed any response?
Yes, I said I didn't agree to it. I did, I said not guilty to it. I have my pictures of this.
Did you file it with the civil department before today?
No.
Okay, it's fine. Okay. Would you both raise your right hands? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Swear.
Thank you. Sir, it's your claim. State your case.
I don't understand.
State that you filed this affidavit and claim.
Yes.
State your case. What's the basis of your case?
I was going in the left lane. The road is too late. I was going in the second lane and she came up from a street.
She the defendant. Miss Freeman. Miss Freeman came out of the street.
Yeah.
Okay.
And she was going the same direction I'm going. She came straight in front of my car on the second lane. We're supposed to take the right lane, the first lane, the right lane. So I tried to avoid, my car was going straight to her door. I tried to avoid that, so I hit the back left of her trunk. Which in my mind, I saved her life. Because I was doing like, I'm going straight and she came right straight in front of me. So I looked face to face to her. And then like the only thing I couldn't go left because the left is going the other way. So I tried to avoid go straight to her door. I turned right and hit the back left of her trunk. My car totally damaged, it jumped. And that's the whole thing.
Has your car been repaired?
No, no way.
Did you submit the claim to your insurance company?
They denied me my insurance, her insurance denied me too.
What was it? Do you have a letter from your insurance company or hers, the basis of the denial of the claim?
I don't have collision on my insurance.
Okay. I need you to wait for 1 second. There are some criminal cases I need to do. I knew this would happen. I said, as soon as I start with you. You don't need to move. Just give me 1 second. Sergeant Otter.
Yes, Your Honor.
This is 220155FY. This is State of Michigan versus Amir Shfa. May I have your
Yes, ma'am.
appearances, please?
Good morning, Your Honor. Sharon Greer, appearing on behalf of Mr. Amir. I am going to call him Mr. Amir. That's easiest for me. Sorry.
Okay. And Mr. Interpreter, would you state your name for the record, please?
Okay. Tibaba Shete.
Mr. Ashetti, would you raise your right hand for me, please? Do you swear or affirm that you would translate English into Is it, I'm hearing,
Amharic, yeah.
okay, from English into American and American into English.
Yes, absolutely.
Thank you. And Mr. Amir, state your name for the record.
አሚር ስምህን እንደኔ ስምህን ተናገር ነው የምትለው።
Amir Nuri Shafa.
Shafa. Today is the day and time set for the arraignment in this case.
ዛሬ
Oh, I'm sorry. Go ahead, Mr. Interpreter. I'm sorry.
ዛሬ የመጣህበትን ጉዳይ ያው እሱ ነው የነገረችኝ። ታስረ የመጣህበትን ጉዳይ። Go ahead, please.
Ms. Greer.
Your Honor, I have gone over the charges and the penalties with Mr. Amir.
ከአሚር ጋራ የቀረበበትን ክስ ምን እንደሆነና ክሱም ምን እንደሚያስከትል ተወያይተናል ነው የምትለው። Go ahead, please.
And it is my understanding that he does now understand that he is being charged with a felony of assault with a dangerous weapon.
የተከሰሰበትንም ምክንያት አስረድቼዋለሁ። ይሄም ማለት አደጋ ሊያደርስ አደገኛ በሆነ መሳሪያ ይዞ ጥቃት ሊያደርስ ከዛ ጋር የተያያዘ እንደሆነ ተነጋግረንበታል፣ ገልጬለታለሁ። Go ahead, please. Do you want me to interpret what he's saying, or do you want
Yes,
to say
Yes,
something?
please, sir.
Yes.
Oh, I didn't do that intentionally.
Even nothing do with the weapon, anything.
I had no intention, no plan at all to hurt anybody with the said weapon.
Today is just the first appearance, and Mr. Shfa should remain quiet. Ms. Greer.
Your Honor, based on my communications through the interpreter, I believe Mr. Shafa understands his charges, and I am submitting to the court that we will waive formal reading of the charge and stand mute to those charges.
Can you say that again, please?
That I believe Mr. Amir understands what he is charged with and the maximum penalties for those charges. And so because of that, I am going to waive the formal reading of the complaint.
The formal reading.
And we will stand mute to those charges.
What does that mean? Standing mute to the long charge?
The court is going to enter a not guilty plea.
Okay. አሁን ምንድነው ምትልህ የሚቻለኝን ያህል ገልጬለታለሁ፣ ተግባብተናል። አሚር ምን እንዳጠፋ በፍርድ ቤቱ በኩል የቀረበበት ክስ ምን እንደሚያስከፍለው ምን እንደሚያስጠይቀው ይሄንን ተነጋግረናል እና እሱ አሁን የምትለው ምንድነው ይሄንን አንተን በማይጎዳ በኩል ፍርድ ቤቱን እንዲያስተላልፈው አጥፍቻለሁ ወደሚለው ለመሄድ ወስኛለሁ ነው የምትለው ጠበቃ። Go ahead, please.
No.
There is a petition for court-appointed attorney attached to the file.
Do you understand? I like the phone. We'll say. If you don't understand, let me know. Okay.
Your Honor, he does have a question. He didn't understand everything that was just said.
The last thing, ለሱ ባይሆን ምክንያቱም እኔ ያላጠፋሁትን ነገር አጥፍቻለሁ ማለቱን አልወደድኩትም።
Yeah, I cannot in my conscience say and admit that I have committed any crime.
Okay.
He did it.
Your
not
Honor.
me, so yeah,
Your
that's
Honor.
what I'm translating what he's saying.
Your Honor, may we go back in the breakout room for just a moment and I'll let you continue with your case and I'll get this straightened out.
Yes, ma'am.
Thank you, Judge.
Thank you. Ms. Greer, before you go, have you talked to the other parties, the other defendants?
No, I have not, Judge.
Okay, okay,
Okay, thank you.
thank you. 213900 OT Country Meadows versus James Wilder. Today is the day and time set for hearing on the plaintiff's motion for issuance of an order of eviction. Mr. Morton.
Your Honor, at this time, we are seeking motion for entry of a order of eviction. The default judgment was previously entered back in October with over $2,700 due at that time. As stated in the motion, $1,000 payment was received, but since that point, now over $8,400 has come due and owing, which has not been paid. We have not received a formal response. We have not received any updates on any sort of SARA application. We've not received any updates at all. Based on that, and based on the defendant's failure to appear, we're asking that the order of eviction be entered today.
This matter was scheduled at 10:30. It's now 10:47 a.m. by the court's clock. There is no one by the name of James Wilder that appears in this court's virtual courtroom. There is no one in the court's Zoom courtroom downstairs based on the defendant's failure to appear this morning. Court will grant the plaintiff's motion for issuance of an order of eviction. Mr. Morton, I am signing the order that was previously submitted to the court. Anything else in this matter, sir?
No, Your Honor.
I think that concludes your docket with me this morning.
This morning, yes, Your Honor. I'll see you again this
Have a
afternoon.
good day, sir.
Thank you.
Yes, sir. We are back on the record in 215471 SC. Mr. Camellia, you indicated to the court that you did not have collision on your vehicle. You did not have collision insurance on your vehicle?
No.
And you submitted the claim. Did you submit the claim to Ms. Freeman's insurance company?
Her insurance, they say, the state of Michigan, everyone puts his own car. And my insurance, the collision, the whole thing, I lost my car. Just bought it about a couple of months ago.
You lost your car?
Yeah, it's junk.
Okay.
So I'm here just, get some money back from my car. It wasn't my fault. Police came in, he questioned her, then he came to me. And I told him what happened, and he said, you match, you and her, you match. I said, that's exactly what happened, and you have the police report. So I'm just, I did my right. I need, I need some money back for my car.
Understood. Anything else, sir?
No.
Ms. Freeman, your response.
Okay, so this happened November 15th. I was leaving out of my apartment complex. In the report, they said that I failed to yield at a yield sign. Is a stop sign coming up out of my apartment complex. I guess they said that I made a left turn. I turned right to the farthest lane close to me. It's Van Born. It's two lanes, two going this way, two going that way. I turned in the farthest lane to the right of me. I turned out right. When I turned out right, it was a black truck went past me. Upon me, I was like a car length away from the light, and that's when I was hit because he came over. He was in the left lane, in this lane. He was in this lane, came over and hit the left side of me. We stopped the car. I stopped my car. I got out. He backed his car up some. He got out, looked at his car, got his scraps from his car, put him in the trunk. The police came to the scene. They took, like she said, my statement, his statement, and then they left. Well, they left with my ID and my registration. Came back and said that he had a witness and they submitted me with a ticket. The officer told me at the time that I can fight the ticket if I wanted to. And that was that. A few weeks later, I got a call from his insurance company saying that they wanted to know what happened. And I let them know what happened. They asked me to send them my documentation of pictures and things like that. They said that they didn't see me at fault. He said that it was a no-fault state, that he was responsible for his own car, and that he didn't have collision. And my insurance company said the same thing, so they weren't willing to pay for his car. My car was totaled out. My insurance company totaled my car out. And that was it.
Anything else, sir?
No.
Anything else, Ms. Freeman? The court did have the opportunity to review the State of Michigan crash report. Page 2 of that document in the bottom right corner indicates that Unit 1, that being you, Ms. Freeman, was making a left turn to go to eastbound Van Born and did not yield to ongoing traffic. The way that they documented the diagram for the crash shows a traffic control device at that corner. It shows a stop sign at that corner. And it further indicates that that unit number 2, which was the plaintiff, was driving eastbound Van Buren, and unit number 1 cut in front of unit 2, and two vehicles collided, should be their two vehicles collided. Based on the statement from the writer of this report, ma'am, the police are indicating that you are at fault for failing to yield as you came off of the side street onto the main street. For that reason, the court will rule in favor of the plaintiff in this matter, but it will not be for the amount requested, not $6,500. Sir, the maximum that you are able to recover by statute is $3,000. That's MCL 500.3135. It indicates that damages of up to $3,000 to a motor vehicle, to the extent that damages are not covered by insurance, are recoverable in this mini tort action, which is what you filed in the small claims court. Again, the court will enter judgment in favor of plaintiff and against defendant for that $3,000 maximum. There's a filing fee in here of $70. There's a service fee. I'm trying to see the total. I see it's a $4 service fee. And then there's some postage in here. $4.73. Sir, was that the entirety of your service? $4.73? Was that is that what you spent for service? $4.73?
Yeah.
Did you have any other costs in filing this case?
No.
So the service fee and the filing fee total $74.73. Total judgment in favor of plaintiff and against defendant, $3,074.73. Anything else, sir?
The fire department, they sent me a bill of $175. I talked to them and said, talk to the judge and go. They came in about half hour after we left, and the whole thing took about half an hour. And they came in after we left, and they split the bill between me and her, $550. They sent me $275 bill.
Did you include that bill in your filing? I didn't see an ambulance bill when I reviewed the file.
Yeah, I didn't review it. Say traffic, you know, they came in like.
If you don't bring it and you don't include it in your filing, the court can't award it. You need some documents. You need something to demonstrate to the court. Ms. Freeman, you're gonna say something?
Yeah, I was just gonna say, I never received the bill. And neither one of us we never left with the EMS.
I am signing the judgment, $3,074.73. Ms. Freeman, are you in a position to make payments on this amount?
Not today.
Okay, ma'am, you can make arrangements either directly with Mr. Camellia, or you can file a motion for installment payments downstairs with the court clerk before you leave.
Okay.
I'll have the officer take the file down. Otherwise, he can take other efforts to collect these monies from you, understood?
Okay.
Mom,
Because she had collision insurance and she give that to the insurance company, that's what they would take that $3,000.
she needs to talk to her insurance company. I don't know why they denied the claim based on the fact that the police report indicates that she was the at-fault driver, but the file's gonna go downstairs. If you want to wait, I'm not sure if there's a clerk available to make a copy for you, enter the judgment. If you're not down there, they'll make a copy and mail it out to you. Anything else, sir?
No.
Anything else, ma'am? You have a good day. Good luck to both of you. Ms. Greer.
Yes, Judge. We are ready to proceed.
Okay, we're back on the record in 220155 FY.
Your Honor, Mr. Amir now understands that this proceeding is just a formal proceeding to inform him of his charges and the penalties and to talk about the bond.
ሚስተር አሚር ጉዳዩ በደንብ ተብራርቶለታል። ክሱ ምን እንደሆነ ምን እንደሚያስከትል ከቦንዱ ጋር የተያዘው ነገር ምን እንደሆነ ይሄ ገብቶታል ተብራርቶለታል ብለው ለዳኛው አይን የነገረችው።
The court has signed the petition for a court-appointed attorney. And Mr. Shaswell will have an attorney going forward.
እንግዲህ ፍርድ ቤቱ ጉዳዩን የሚከታተል ጠበቃ ያዘጋጃል ነው የምትለው።
As for bond, Romulus Police Department recommends 25,000, 10% with no contact and GPS tether.
Your Honor, oh, I'm sorry. Go ahead.
ያው ሂሳቡን ነው የጠቀሰችው እስከ 2500 ከዛ ደግሞ የመክፈት ካልቻለ ቅድም የተነገረ አንገት ላይ ተደርጎ አንተን የሚከታተሉ ነገር ያ ይደረግባል ነው የምትለው። እንግዲህ እንስማ የሚሉትን go ahead please.
Your Honor, Mr. Amir understands that he cannot go back to this apartment where this incident occurred.
Mr. Amir, ይሄ አደጋ ወይም ከተከሰተ በኋላ እንደገና እዛ ቤት መመለስ እንደሌለበት ተነግሮታል፣ እሱም ገብቶታል።
And we believe that the recommendation from the police department is excessive to ensure his appearance and to protect the community.
አዎ የ2500 ፖሊስ የወሰነበት በእኛ በሷ በኩል ሲታይ ትክክለኛ መስሎ አይታይም። እሱንም ይጎዳዋል፣ ማህበረሰቡንም ይጎዳዋል። አሁን ባለበትም ሁኔታ መልካም ነው ብዬ አልቀበለውም ነው የምትለው።
Mr. Amir works at Amazon and he has worked there for 1 year and 6 months.
Mr. Amir አማዞን በሚባለው መስሪያ ቤት ከ1 ዓመት 6 ወር ያህል ሰርቷል።
He has stability in the community. He does have other relatives that live in the community that he would be able to stay with other relatives.
እና ሚስተር አሚር ባለበት ማህበረሰብ ውስጥ በሚገኝበት አካባቢ ማለት ነው ባበሻው የተግባባ ግንኙነት አለው፣ ሰዎችም የሚያውቃቸው አሉ እና ከዛ ቤት ወጥቶ ለጊዜው የሚቆይበት አያጣም። ችግር ያለበት ሰው ነው ብዬ አልገምትም።
I've asked Mr. Amir, or I have informed Mr. Amir of the recommendation from the police department, and he is not opposed to some type of cash bond, but would not like the court to impose a tether upon him.
ለሚስተር አሚር ፖሊስ ይህንን ያህል መክፈል አለበት የሚለው ተነግሮታል። ግዴታ ከሆነ እከፍላለሁ የሚል እንትን አሳይቷል መስማማት። ነገር ግን ባንገቱ ላይ ይሄ ፖሊሶች የሚከታተሉት ነገር እንዲታሰርለት ያንን እንደማይፈቅድ ነግሮኛል።
Bond is set at 5,000, 10%.
ይገባኛል።
Defendant is not to return to 35925 Herman in Romulus.
Is that
He needs
being
to have no-
relayed to him, Mr. Interpreter?
Yeah, no, I didn't get, Judge, can you say that again? It is, maybe it's the volume. I didn't get that quite well.
The bond is set at 5,000, 10%.
Oh, how can I explain that to him? 5,000, 10%.
He needs to post $500.
Okay, 500 ብር መክፈል ይኖርብሃል። ቦንዱ ይህንን ነው የሚጠይቀው። 500
He's not to return to the Herman Street address.
እዛ ቦታ ላይ ያ አድሬሱ የተጠቀሰበት ቦታ ይሄ ሩሜት ያለበት ቦታ እዛ ድርሽም ማለት የለብህም።
He's to have no contact with Zihan Abibi.
ከዲሆን አቢቢ ከተባለው ግለሰብ ጋራ ምንም አይነት ግንኙነት እንዲኖር አይፈቀድልህም።
No contact means no contact at all in any way.
አዎ ይሄ ነው ኮንታክት ማለት በማንኛውም ጊዜ በምንም አይነት ሁኔታ ከዚህ ከተባለው ግለሰብ ጋራ ግንኙነት ሊኖር አይገባም።
His next court date is March the 9th at 8:30 a.m.
የሚቀጥለው ፍርድ ቤት የምትቀርብበት ቀን ማርች 9 ነው የሚሆነው። Did you say what is the time again? Your Honor?
March the 9th at 8:30 a.m.
8:30 ማለት 8 ተኩል ማለት ነው ጠዋት።
Back with me. They'll give him a notice before he leaves.
አስቀድሞ ይሰጣል እንትኑ ምንድነው ማስታወሻ ይሰጣል። ቀኑን ያዘው ማርች 9
Sergeant Otter, again, this is case number 220155 FY PCC date of March 9th, 2022 at 8:30 a.m. in courtroom number 1 by Zoom with me.
Thank you, Your Honor.
Anything else, Sergeant?
No, ma'am. Just a reminder, we have 2 more that have not spoken with an attorney yet.
I know. Anything else, Dr. Ashidi?
Oh, no, not at all. Thank you so much.
Thank you so very much, sir. I'm sure they'll need you again on March 9th.
Okay.
Thank you. Thank you, Ms. Greer.
Thank you, Judge. I'm going to stay on so that I can speak with the other.
I have one to say.
Mr. Sva has his hand up.
Go ahead.
እንትን አለ እኮ I have my staff is in his arrest now. I'm his roommate and my staffs are in his arrest. All my staffs are in his arrest today. So all the I need that stuff because it's gonna help me. Without them, my debit card, my bank documents, my work IDs, my car is in there, my bed. So I gonna move that stuff for 1 day or something.
ይፈቀድልኝ ነው ወይስ እንዴት ነው የማደርገው ነው?
Yeah, I gonna move. Yeah, ይፈቀድልኝ.
How would I do if I have no Your Honorable has said I don't need to make any kind of contact. No contact means no contact, but I have my documents there, my property, how would I get my stuffs back? Could I do it with some help or how? That's his question.
With the police as the civil standby for you to retrieve property?
I could explain that to him, Your Honor.
Thank you so very much.
Yes, ma'am.
እሱን እኛ ከፖሊሶቹ ጋር ተነጋገርበት ነው የሚሉ።
Okay.
We will go with you. Okay.
Okay?
Okay. Thank you, Your Honor.
Thank you much. Thank you much. Everyone have a good day.
Thank you, Judge. Thank you, Doctor.
Okay, thank you too.
Did Ms. Greer go back into the breakout already? Good, okay.
Oh,
Ms. Greer, you're just doing the most. Your audio's on, but I can't hear you.
My son is using his Bluetooth, and so I keep switching over, and I can hear. Okay, Judge, guess what? We may need an interpreter for Miss Cooper.
What kind of interpreter?
I'm not sure, but her language is it's broken, and English, and I asked her what was her native language, and I don't even know what she said. But it's very
Sergeant Otter? Where? Miss Cooper?
Yes, ma'am.
Is the police officer there with you?
No, he left around.
Judge, I'm calling the police department now.
Thank you.
Because she had an objection to something that I really didn't understand what the objection was. Boy.
Officer is on the way back into the room.
Thank you. Ms. Greer, did you talk to Ms. Cooper about both files?
Well, I just got started with Miss Cooper, and she had an objection right from the beginning when it was explaining to her the purpose of today's hearing.
Because of the purpose or because of the language barrier?
Because of I didn't understand what she was objecting to, Your Honor. So I'm not really sure. Maybe someone
let's try
else
this then.
may be able to understand her.
This is 220158 SM. This is State of Michigan versus Sony Cooper. Ms. Cooper, is English your native language?
Yes, sir.
Yes? What was your objection to speaking with Ms. Greer?
I'm EXO background is like from Cobo Hall to Canada Bridge.
I'm sorry? You said your background is?
She was wondering why you objected to the attorney.
I didn't. I want to ask her. I say your background shows like a bridge from Michigan to Canada Bridge.
Oh, my background.
The background of your screen, yeah.
Oh my goodness. Okay. That's just a picture behind me. That's all that is. And I clearly did not understand what she was saying to me, Your Honor.
Okay.
It may be helpful if the sergeant just stays there. Is that okay? I'm not sure what to do at this point, but it may be better if he's there, because I clearly did not hear that.
So what do you need to speak to her again, to Ms. Cooper, since you didn't get beyond the objection to the background?
Right, and I didn't understand what
Okay.
she was saying.
You understand
So-
the picture behind her? It's like how people put a screen behind them just so it's.
But she can go away to convince me.
No, it's so people don't see, maybe if she's in her house, they don't see things in her house. It's just so that it's a generic background.
But she's not in there. I see that it's a familiar judge that she connected with.
The judge is on a different, everybody is on cameras like we are. So we're all on different cameras. This is the judge. She's in the big chair. She's got the flag in her background. And your attorney, that's just a generic background. So that, again, if she's at home, it doesn't show, or if she's somewhere she doesn't want people to see the personal things.
She said, "Well, her name again?"
Her name is Mrs. Greer. She's an attorney.
Well, do I need an attorney in this case?
You have a right to an attorney, yes.
Yeah, but do I have a right to just plead for myself?
That's your right, but usually you would want to talk to her first, and you guys could talk together alone, and you could make that decision on your own. With
I don't need an attorney.
You don't want an attorney?
No.
Okay.
Ms. Cooper.
Yes, sir. Serena.
You signed a form that indicated that you wanted to use the court-appointed attorney.
The papers were given beyond the window, so I asked usually to read what it was, and then the arresting officer said, "You just need to sign." So I said, "I'm not seeing the caption."
Your Honor,
Do you not?
I'm going to take my background down, first of all. Maybe that will help.
I do not need Anthony.
Okay, Ms. Cooper, it's your absolute right to proceed on your own. Is that what you want to do this morning?
Yes, ma'am.
Okay, this is 220158 SM. This is the state of Michigan versus Sony Cooper. Ms. Cooper, you are being charged with a misdemeanor in this matter. It's alleged that on February 27th, 2022, in the city of Romulus, you committed count 1, domestic violence. It's alleged that you did make an assault or an assault and battery against Corzo Kanger, a resident or former resident of your household, contrary to MCL 750.81 parentheses 2. This is a misdemeanor punishable by up to 93 days in jail and fines of up to $500 plus court costs. Count 2, domestic violence, that you did make an assault or an assault and battery against Corzo Kanger, a resident or former resident of your household, contrary to MCL 750.81 parentheses 2. Ma'am, for purposes of arraignment, the court will enter a plea of not guilty on your behalf. There is a recommendation from the police department that your bond be set at 10,000, 10%, and that you have no contact with Corzo Kanger. Is there anything you'd like to say about bond in this matter?
The date it happened was on the 28th.
Ms. Cooper, are you employed?
No.
When was the last time that you worked?
December 19, December 6, 2019.
How do you support yourself?
That's what I yet to get from the state, because I went to my bank to check on the unemployment that I should have received from my employers, and none of them is up to present, the bank has not contacted me. So I basically, my children been chipping.
Ma'am, if you're not allowed to go back to Gateway Drive, do you have someplace else you can go?
And I have a home on Pond Street, Inkster, Michigan, 48141.
Is there any reason for you to have contact with Korzu Kanger while this matter is pending?
Cousin Kanger is my late sister.
You were fighting with your sister?
Says you were fighting with me.
Wait, I'm sorry, ma'am, don't respond to me.
All right.
Is there any reason why you can, is it possible for you to not have contact with her while this matter is pending?
Not really. I have to check on the kids.
How old are your kids?
And the last one is 16. The last one is 16, and the next to that is 17. And next to that one is 21 going to 22. And then that's the one in the military, US Army. And then the bigger one is in theater. She's 24, I think 24, 25 now.
We're deciding right now.
Ms. Cooper?
Yes.
The police department is asking for your bond to be set at 10,000, 10%. I'm going to deviate from that. Your bond is 5,000 personal. You do not have to post any money, but what you must do is return for all future court dates. Would you give me that address in Inkster again where you're going?
29754 Pine Street, Inkster, Michigan, 48141.
Did you say Pine Street? P-I-N-E?
P-I-N-E.
Ma'am, you are to have no contact with the victim in this case, that being Korzu Kanger, K-O-R-Z-U, last name K-A-N-G-A-R. Ma'am, no contact means no contact, no direct contact, no contact through third parties, no contact through social media. You list your children as being 16, 17, and 21. That means you can have contact with them outside of whatever this is with Ms. Kanger. Do not return to 32690 Gateway Drive in the city of Romulus. Ma'am, if you violate the terms of your bond could be revoked and you can spend the rest of this case in custody. Do you understand?
I do. May I ask a question?
1 second. Your next court date will be March 9th, 2022 at 9:30 a.m. That will be back with me, back by Zoom, March 9th, 2022, in the case that's 220158 SM. Ms. Cooper, what's your question?
The question is, I have few wearings out there, so how can I get it?
You have
my wearings.
You have what out there?
Yeah.
She's saying her wearings, like her clothing, personal items.
Her clothings are a gateway?
Yeah.
Ma'am, is it all of your clothing or just some clothing?
Oh.
The police can provide assistance to help you get what you need to get through your next court dates. They can do a civil standby to assist you in this matter. Ma'am, you also have 195311OM. This is another misdemeanor violation of parental responsibility. In this case, the court's going to enter a plea of not guilty on your behalf. Your next appearance, it set your bond at 5,000 personal on this one as well. Your next appearance date will be March the 17th at 10:50 a.m. The warrant in this matter has already been canceled.
Your Honor, what was the time on that and also the case number again, please?
The case number again, Sergeant, is 195311 OM. March the 17th at 10:50 a.m., 1050 a.m.
Thank you, Your Honor.
Anything else, Ms. Cooper?
No, ma'am.
I will see you on March 9th. Anything else, Sergeant?
No, Your Honor.
Thank you. Have a good day.
Thank you.
Oh, wait, you're not
We
done
just had the
yet.
one other, yes, ma'am. Nothing else in
Smith.
this case.
Thank you.
Thank you, Judge.
Thank you, Ms. Greer. Always a pleasure to see you.
I will be waiting for Miss Smith as well. Hopefully I can do a little better.
Are you waiting for Ms. Smith? Yes.
Yes.
Okay. I suspect. Why do I smell like, Marianne, it smells like it's fresh wood. You know, when they cut wood with a circular saw? I'm smelling that. That's not a good sign. She has a stack of stuff. Go down for me, thanks.
Judge, do you happen to have the Van Buren file for Graves?
I do. Ken just handed me that one and Huron.
Okay, just wanted to give you a heads up. The prosecutor for Mr. Graves will be appearing on Zoom, Elizabeth Dornick.
Okay.
I just sent Andy a chat, Judge, about my
About
time.
what we just discussed. Absolutely, that's fine. I
Thanks.
understand.
Thank you. She said that's cool.
Wonderful.
Thank you.
It's all about teamwork. We keep talking about it.
Yeah, you're right. So I'll be here until like 5 too.
You'll be here until you're not. Wonderful.
Thank you.
And Andy, see, this is why I left, to go get the ability to sign the forms for Andy. They must be working on the roof.
Working on the what?
They're working upstairs.
Oh,
I hope so. Otherwise, we need to have a different conversation about safety and evacuations. Mm. Mm. I'm still curious how you were hearing music earlier.
You and me both. Kind of scary.
You saw a glass truck here this morning? Is that what you said?
Yeah, that it was going past our building to the back of the old building.
That doesn't explain who's upstairs.
You're right.
Are we ready with Ms. Smith?
Yes, Judge.
We have 21 RP 02308 OM. City of Romulus versus Shatira Smith. Appearances, please.
Sharon Greer appearing on behalf of Ms. Smith, Your Honor.
Ms. Smith, would you state your name for the record, please, ma'am?
You know, I didn't. Oh, yeah, I'm Miss Shatira Smith. Miss Shatira Smith. Cherie Smith.
Thank you. Today is the day and time set for the arraignment on this misdemeanor matter. Ms. Greer, how are we proceeding this morning?
Your Honor, I have explained to Ms. Smith what the charges are and the penalties for those charges. And for that reason, I'm going to waive the court's formal reading of those charges. And Ms. Smith will stand mute and ask the court to enter a not guilty plea for her.
Thank you. Ms. Smith, were you able to hear Ms. Greer just now?
Yeah.
Okay. Ms. Greer, there's a recommendation from Romulus Police Department that Ms. Smith's bond be set at $5,000. It doesn't indicate personal or cash. Indicates that she has some outstanding warrants, some other pending charges. Do you have some comment on bond?
Yes, Judge, I have spoken with Ms. Smith in regards to her outstanding charges, outstanding warrants and pending charges with the 34th District Court. I've indicated to her the police department's recommendation of $5,000. She has indicated to me that she has no money that she could post a bond. She's not employed at this time, Your Honor. I asked her about a GPS tether and whether or not she would have a place where she could be tethered to. She's indicating to me that she does not have a place. Specifically, she has 2 or 3 places that she goes with other people, and she has a permanent mailing address that is listed on the court forms in Canton, Michigan. So she's asking the court not to impose a cash bond, as well as not to impose a tether and give her a personal bond.
I don't see thank you, Ms. Greer. The court does not see a tether requirement on here, and it's 5,000 with no indication of cash or personal. Court will enter a bond of 5,000 personal. Ms. Smith does not need to post any money, but what she must do is appear at the next hearing. In this case, 21 RP 02308. That next hearing date will be April the 7th, 2022 at 9:10 a.m., 9:10 a.m. That will be with Judge Green in courtroom number 3. That is just the Romulus matter. Ms. Smith has some other outstanding matters, Ms. Greer, which I think you alluded to. These are all trespassing cases from Detroit Metro Airport. This is 21 WM 01724 OM, the trespassing at the airport from August 1st, 2021. 21 WM 02107 OM, again, trespass at the airport from September 30th, 2021. And then 21 WM 02495 OM, Wayne County Airport versus Smith. The trespass date is November 23rd, 2021. Ms. Greer, does not appear that Ms. Smith had been previously arraigned in any of these cases.
Your Honor, I have gone over those charges with her as well. And for that reason, we'll ask the court to waive the formal reading of those charges, and she will stand mute to those charges.
Thank you. There is no bond information from the airport in any of these files. Bond will be set at 5,000 personal in each of these matters. Ms. Smith is not to return to Detroit Metro Airport located in the city of Romulus. The next appearance dates in all of these files will be March the 17th, 2022 at 10:10 a.m. in courtroom number 2 with Judge Oakley. Anything else, Ms. Greer, for Ms. Smith?
No, Your Honor.
So
Thank
with
you.
that,
Anything
you
else,
have to
Sergeant
pay
Iyer?
for the 17th?
No, you're gonna be like on a personal bond, which means you do not have to post any money.
Okay,
And as long as you show up.
to the 17th.
Yes, ma'am.
Okay.
Anything else, Sergeant?
No, Your Honor, that's all.
Thank you, sir. Thank you for your patience this morning. Have a good day.
Thank you, ma'am. You too.
Thank you. Ms. Greer, Ms. Graves is here, and the prosecutor on the case is here as well. Marianne will get you into a breakout room with Mr. Graves.
Okay, Your Honor.
Thank you.
Mm-hmm.
This is 220159 FY, State of Michigan versus Richard Allen Graves. May I have your appearances, please?
Good
Karen
morning.
Pearson- I'm sorry. Oh, there's a prosecutor there.
Sorry. Good morning, Your Honor. Elizabeth Dornick appearing on behalf of the people, P79420.
And Sharon Greer, P40133, appearing on behalf of Mr. Graves in this matter.
Mr. Graves, would you state your name for me, please?
Richard Allen Graves.
Thank you. Today is the day and time set for your arraignment on these felony charges. Ms. Greer, what say you for the arraignment, ma'am?
Your Honor, as it relates to the arraignment, we will waive the formal reading and stand mute. I have gone over the charges and the penalties with Mr. Graves, and he does understand those.
Mr. Graves, were you able to hear Ms. Greer just now?
Yes.
Okay, waive formal reading, stand mute to the charges.
Yes.
Mr. Graves, you have a right to be represented by an attorney. If you can't afford to hire an attorney on your own, the court can appoint one for you. There was a petition for court-appointed attorney attached to the front of your file. Court has signed that. You will be assigned counsel going forward. Sir, you also have the right to be considered for pretrial release. There is a recommendation from Van Buren Township Department of Public Safety that your bond be set at 10,000, 10%, that you do not return to 46650 Bemis in Van Buren Township, that you have no contact with John Graves, that you go into inpatient mental health program, and that GPS tether accompany all of these other conditions for your pretrial release. Ms. Greer, what say you as to this recommendation?
Well, Judge, I asked Mr. Graves about the inpatient mental health recommendation, and he's indicating to me that he's never received any type of or has a problem or has received any type of treatment for mental health issues. I've talked to him about a different place to live as opposed to going back to the residence where this event occurred. He's indicated to me that he does have another place that he can go to and stay. He's self-employed. He is a carpenter. He's 59 years old. He does have some priors, Your Honor, but it appears that, I mean, his priors, the habitual fourth, it takes you back all the way back to 1985. And it looks like the last one that might even be relevant was in 2013. So it doesn't appear that we are dealing with someone that is a complete danger to society. Maybe to the residents where he was, he might not be welcome back there again for a while, but society in general, I think he will show up for all of his court dates. And I believe if we can keep him away from this residence in Van Buren Township, that we wouldn't have any more problems with him at all. And so for that reason, I'm asking the court if you would consider a personal bond for him.
Dornick.
Thank you, Your Honor. And the reason that I and Detective Long are recommending that the defendant be placed or be required to attend to a mental health treatment facility is as follows. The defendant on February 24th, police were called about him claiming that a motorcycle gang or a biker gang of some kind is trying to kill him. The complaining witness in the current offense, his father, Mr. John Groves, indicated he would petition the defendant. I don't know if he was successful. I know he wasn't really successfully petitioned because he was not hospitalized. So I don't know if he was actually petitioned. On February 26th, the defendant called the police, telling the police that a biker gang is out to kill him. He claimed at that time he was using Suboxone, and he refused to go to the hospital. And then we have this current offense, which is what this charges stem from, where he pries open his father's lockbox, which has a handgun in it, and then proceeds to run around the home with the gun, claiming again that there's a biker gang out to get him. I don't know what is going on with the defendant, but something is seriously going on, and I'm seriously concerned about what it is. Maybe it's just that he's using narcotics. There was an indication from his sister that he might have used crack cocaine. I don't know. Dad indicated he uses marijuana regularly. I don't know what the problem is, but there's a serious problem, and the things that he's doing are escalating, and he's becoming, although not incredibly violent, he's becoming more violent, and he's getting weapons, which is of great concern to the people. I understand that the defendant also believes that his dad, who is an elderly man, 80 some odd years old, and his brother are somehow involved in this biker gang. So that puts additional concern there too. And then basically, that is also indicated to me that he's not working, he's not employed, and hasn't been working for quite some time because he has some physical disabilities. So I'm exceptionally concerned that there is a mental health problem here. Maybe it's just a substance abuse problem, but there's a mental health problem that needs to be addressed immediately because he poses a risk to not only his family, but in my opinion, society, as it is escalating. With that, Judge, I would ask that that requirement be put into place.
Anything else, Ms. Greer?
Judge, if I could just respond briefly.
Yes,
the report does indicate that Mr. Graves was taken to the hospital and that he was released. So it would appear that there was some type of evaluation that was made at the hospital that he was released, that he was not of a nature that they would recommend that he be placed in some type of facility. So that's the first argument I would have against this court ordering him to go into a mental health treatment facility. I don't think that that is the way the court should proceed with a criminal matter. If in fact someone believes that he needs to be hospitalized, I think that the way to go is to actually, the family should try to petition for him to be submitted to some type of facility or hospitalized. If the court orders no contact with the family, then the family is protected. In that regard, he's not to go there. He's not to have any contact with them. And I think that that condition is overreaching at this point in time. The court could accomplish what it's trying to do, or what the prosecutor would like for the court to do with a tether. If it comes to that, it could be a tether as opposed to ordering someone into a mental health facility at this point in time with these type of allegations on the record. I mean, just, saying that someone is out to get you, I don't know if that rises to the level of, I don't think his actions at this point rises to the level of him being taken in and put into a mental health facility at this time, with all that encompasses, him going into a hospital setting. I mean, you just can't get into a mental health facility. You got to go through the hospital, and it's a whole lot of different things that that's required. So I'm asking the court not to do that at this point in time.
Thank you, ma'am. At this time, the court will set Mr. Graves' bond at 10,000, 10%. He is to have no contact with John Graves. Mr. Graves, that means no direct contact, no contact through third parties, no contact through social media. Do not return to 46650 Bemis in Van Buren Township. Your attempt to return to this property or have contact with John Graves could be viewed as a violation of your bond conditions. Your bond could be revoked and you could spend the rest of these proceedings in custody. You are not to be released without a GPS tether in place. Your next appearance date on this file 220159FY will be on Wednesday, March 9, 2022 at 8:30 a.m. That's back with me, back by Zoom. Courtroom number 1. Anything else, Ms. Greer?
Your Honor, I would ask the court, would you consider the personal bond with the tether as opposed to the 10,000, 10%? Could it be a personal with a tether?
Respectfully, Ms. Greer, no. APA Dornick recited at least 3 incidents of police involvement in less than a week's time, which gives me great concern. The allegation recited by Ms. Dornick is that Mr. Graves broke into a lockbox and had a gun inside of a residence and threatened a more than 80-year-old man in his own home. Again, although the court appreciates that these are just allegations, it's serious and it sounds like it might be in fact escalating. I'm deviating from the mental health treatment issue and leaving the GPS tether in place. I think that accomplishes everything that the APA and the detective were after. And if your client wants to revisit the issue of bond or at the March 9th PCC, the court will take it up at that time. But right now, because these 3 incidents happened in the span of just a handful of days, the court will leave that requirement in place.
Your Honor, if I
Anything else,
may.
Ms. Greer?
Thank you. No, Judge, nothing from.
Anything else, Ms. Dornick?
No, thank you very much for your time, Your Honor.
Wait 1 second. Detective Long, was that you or was that Mr. Graves?
Yeah, it was me. Good afternoon. In addition to what the API and I spoke about, being that Mr. Graves is believed to take some types of medication, can we also add no alcohol or no mind altering substances? Being that he's not going into some type of rehab or anything.
Ms. Greer?
Well, Judge, I don't think that we have enough on the record at this point to substantiate Mr. Graves engaging in legal activities. If in fact we wanted to say no illicit or no illegal drug use, I think that's appropriate.
That's fine.
I just don't see.
I think no illegal drug use is implied in moving throughout, it's not, it doesn't make any sense for me to say no cocaine while this matter is pending. It's not a legal substance. I'm going to leave it respectfully, Detective Long. I'll leave it the way that it is for now. If something occurs between now and March 9th, we'll take it up either as motioned or requested by the APA or requested by Defense Counsel. March 9th, Mr. Graves.
Thank you.
Thank you, sir. Ms. Greer, the
thank you.
2 from Huron Township are here. Thank you, Detective.
Thank
Your
you.
Honor, may I have just 2 minutes?
Absolutely.
It's been a
When
long
you come
morning.
back, I'll put you in with Huron. I understand.
Thank you.
Yes, ma'am.
I'm back, Judge.
Thank you, ma'am. We'll get you moved into, oh, you can go back into room number 1 with Huron.
Okay,
Thank you, ma'am.
thank you, Judge.
Judge, just as a FYI, I did go ahead and send the PTR for Graves.
Thank you, ma'am. Did we lose Miss Greer?
I believe they're both in the, oh. Well, that's strange because I don't see anybody in the breakout rooms either.
Yeah,
Is that the same thing you're looking at?
That's what I'm looking at.
All right, I will call her and see what's going on.
Oh, Andy.
Hi, Your Honor, can you hear me?
I can hear you. We lost you for a second there. What happened to?
I don't know. Yeah, she's there.
I can hear you. Can you hear me? Oh, boy.
I'll call the PD.
Yeah, they look like they should be good.
It's not a live stream. I said it'll be live streamed. Well, we'll step out of the picture. It's gonna be on YouTube live stream. Oh, found it in there. I don't have a number for her. It's right. Phone laptop. Oh, that's.
Yeah.
I'm gonna send Andy back from the court to that phone, okay?
What?
I'm gonna
Okay.
send Andy from the court.
Okay.
Andy phone in there.
Okay.
Ms. Greer is back. Ms. Greer?
Judge?
Hello?
I'm here. Huron's here, but I'm not sure if they're hearing us.
Yeah, they put up a sign for me to call and I called the number, but I couldn't get through. So that's why I'm coming back on my computer in case I need to use the phone, but it wouldn't let me through. It just kept repeating the same message. Whew.
Had you finished speaking with both individuals?
No, Judge, they
Okay.
could never hear me from the beginning.
Can you guys hear us in this meeting now?
Finally.
Yes, sir.
Yes, okay.
Okay, there we go. I think we got it. All right, thank you.
Okay.
They have getting that echo from I'm not sure where.
All right, they'll be up in just one moment.
Yes, sir. Thank you, Andy.
Friday. Not up.
Good
Okay.
morning, good after, is it still morning? No, it's afternoon. Good afternoon, Mr. Williams.
Good afternoon, Your Honor.
Your case is not scheduled until 1 o'clock. I'm still on the morning docket.
Okay,
You need to mute yourself.
okay, I'll mute myself. Okay, I'm sorry. I'll
That's
mute
okay.
myself. All right.
Judge Jackson.
Judge, the police department said they didn't have a button to leave the breakout room.
Well, they're
There
back,
you go.
so.
There they are.
And who did you speak with, Ms. Greer?
I spoke with both of them.
Okay.
So we
Sir, with the gray shirt and the beard, your name, please?
Mother.
Nope, you right there, sir. Don't walk away.
No, you're just getting closer, Your Honor. Hello.
Oh, wonderful.
Your Honor, how you doing?
I'm good. What's your name, sir?
Curtis Baylog.
Thank you, Mr. Baylor. I just wanted to have the right file. This is 220162SM. It's the state of Michigan versus Curtis Baylor. Today is the day and time for your arraignment on the domestic violence charge, sir, from February 27, 2022.
Sharon Greer, appearing on behalf of Mr. Bailoff, Your Honor. As to the charges, I have read the felony complaint, the misdemeanor complaint, and the penalties for those charges to Mr. Bailoff, and for that reason, we will waive the formal reading of that information, stand mute to those charges, ask the court to enter not guilty.
Thank you, Ms. Greer. The court will do that. There is a recommendation for bond from Huron Township for 2,010% with the conditions of no contact with the victim, Miss Amanda Bailoff, and no drugs or alcohol. What say you to this bond request?
Your Honor, as to 2,010%, that's a fair assessment, and Mr. Bailoff knows that he cannot have any contact with the complainant, the residents, and the drinking and the drugs, which we would acknowledge may have had a lot to do with why he's here today. So he does understand that he's not to engage in that activity.
Thank you. For this 220162 case, court will adopt the recommendation by Huron Township and set bond in this matter at 2,010%. Mr. Bailoff, you to have no contact with Amanda Bailoff, no drugs or alcohol during the pendency of this matter. Your next court date for the domestic violence case will be March the 22nd, 2022 at 9:20 a.m. That's with me, back by Zoom, courtroom number 1. The officers will give you a notice for that date for this particular file. There is a second matter. There is 210076 FY, State of Michigan versus Curtis Todd Bailoff. Ms. Greer, I again note your appearance for purposes of arraignment in this matter.
Your Honor, we would stand mute and waive the formal reading of the charges in the second complaint and warrant.
Thank you. Mr. Bailoff, were you able to hear Ms. Greer just now?
Yes.
This is a felony matter. You have an absolute right to be represented by the attorney in this matter. If you're unable to afford an attorney, the court will appoint one for you. There was a petition for court-appointed attorney attached to the front of your file. I have signed that. You will be assigned counsel going forward. The next step in these proceedings, sir, is that you have an absolute right to be considered for pretrial release. The recommendation from Huron Township indicates that they are requesting a cash bond and that you be prohibited from purchase or possession of a firearm. Ms. Greer, what say you in response to this recommendation?
Your Honor, I didn't see that recommendation. I got so many files going here at one time. The cash bond amount, Your Honor?
It doesn't have an amount. It just says the police department requests a cash bond to ensure the appearance of the defendant.
And Your Honor, I would ask that the court to impose a personal bond. We do have 2,010% on the other case, and I'm asking, I think the conditions of no contact and no drugs or alcohol would is sufficient for this case as well as the other case.
Thank you. Ms. Greer, looking at it, there's possession of, you waive the reading, but just so you understand the logic of the court in this matter, There's open intox, operating while intoxicated. So the court does not feel comfortable in setting a cash bond, setting a personal bond. We'll set the same 2,010% in this file. No alcohol or controlled substances during the pendency of this case. The next appearance in 210076 FY will be March the 9th, 2022, 8:30 a.m. That'll be back with me in courtroom number 1. So March 9th on the felony, March 22nd on the misdemeanor matter. Anything else from Mr. Bailoff, Ms. Greer?
No, Your Honor.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Mr. Bailoff, I'll see you on the 9th.
Thank you.
Thank you. Mr. Loy, this is 220163 FY, State of Michigan versus Zachary Russell Loy.
Your Honor, Sharon Greer on behalf of Mr. Loy. As to the reading, we would waive the formal reading and stand mute to the charges.
Sir, would you state your name for me, please?
Zachary Loy.
Thank you, Mr. Loy. Were you able to hear Ms. Greer just now?
Yes. Yes, ma'am.
Thank you. Mr. Loy, the next step in these proceedings, I'm sorry, this is a felony case. You have an absolute right to be represented by an attorney. If you're not able to afford an attorney, the court will appoint one for you. There was a petition for a court-appointed attorney attached to the front of your file. The court has signed that. You will be assigned counsel going forward. The next step in these proceedings is that you have a right to be considered for pretrial release. The recommendation from here on is that your bond be set at 5,010%, and you have no contact with the complaining victim in this case, that being Ashley Akey. Ms. Greer, what say you to this bond recommendation?
Your Honor, Mr. Loy is a stay-at-home parent for the 5 children in the household. So any cash bond is actually prohibitive for him to be able to post at this time. We're asking the court for a personal bond. He denies the allegations of the crimes vigorously and will be defending them. We're asking the court if you would impose a personal bond. He understands that he cannot return to the location or have any contact with his wife until these matters have been resolved.
Mr. Loy, on your petition for a court-appointed attorney, you list yourself as self-employed. How do you support yourself, sir?
Self-employed. They asked me if I had a job, and I said I don't have a job. I take care of my children every day. She works the full-time job, and I take care of the kids. I don't know why the paperwork would have been any different.
Mr. Loy, have you ever failed to appear for a court date?
No.
When was the last time you were employed, sir?
Probably right before our first child was born, over 12 years ago. This is a farce, Your Honor.
Mr. Loy, I'm going to ask you not to say anything about the underlying charges, okay?
Okay.
Ms. Greer, the court will deviate from the recommendation, set Mr. Loy's bond at 5,000 personal. Mr. Loy, a condition of your bond is that you have no contact with Ashley Akey, A-I-K-E-Y. Sir, no contact means no contact, no direct contact, no contact through third parties, no contact through social media. Understood?
Yes, ma'am.
Sir, if you make any effort to contact her and is relayed to this court, it could be considered a violation of your conditions of bond, which could result in your bond being revoked and you spending the rest of these proceedings in custody. Understood?
Yes, ma'am.
Your
Can I
next
ask a
appearance date in
question?
this matter will be, I'm sorry, give me 1 second and I'll answer your question if possible. Your next
Okay,
appearance
sure.
date in this matter will be March 9, 2022 at 9:45 a.m. That's back with me in virtual courtroom number 1. Again, this file number is 220163. Next date, March 9th at 9:45. What's your question, Mr. Loy?
I really want to see my children. If I can't third party talk to her, how is that possible to see my children?
Mr. Loy, you're back here in 8 days. I hear what you're saying, but right now there's a balancing of your threat to the community, okay? There's an allegation in the file. The police department have requested certain things for your bond conditions. I'm deviating from it a bit. If your attorney wants to take up the matter of changing the bond conditions on March 9th, we'll take it up at that time, okay, sir?
Okay,
Reasonable?
sounds fine to me. I will stay away.
I'll see you on March 9th, sir.
Your Honor, what was the case number for Mr. Bailov's OWI third case number?
210076 SM. Wait,
All
I'm
right, thank
sorry.
you, Your Honor.
210076 FY.
All right, thank you, Your Honor.
Thank you, sir. Have a good day. Thank you, Ms. Greer.
You too.
Thank you.
Thank you, Judge.
Thank you.
That's it, Ms. Greer. I'm rolling right into my 1 o'clock docket from my 9 o'clock. That works out perfectly.
Oh my goodness. Well, I hope you get a break soon.
There's no break. We'll work right through. It's fine.
Oh boy.
Because my 1 o'clock case is here. Both sides are already here.
Oh my
But it's good to see you, ma'am. Have a good afternoon.
You too, Judge. Thank you very much.
Thank you.
Bye-bye.
Bye-bye. Mr. Hill.
Afternoon, Your Honor.
Good afternoon, sir. Are you ready to proceed on Midland versus Williams?
Yes, Your Honor. I think we might like to talk to Mr. Williams perhaps in a breakout room. We have a motion to compel. We've received some answers since that time.
He's here. My next question was going to be, do you want to go into the breakout room? Mr. Williams was walking around for one moment, but let me get you into a breakout room, okay?
Okay, thank you.
Mr. Williams, please join Mr. Hill in breakout room number 1. You'll see the invitation in just a moment.
Oh, okay.
Thank you.
Judge, I am going to go ahead and hop out of the Zoom meeting. Did you need anything else from me before I leave?
I didn't, ma'am. Thank you much. The files are up here if somebody wants to come grab them for you.
Okay, perfect. And I did go ahead and send you the PTRs for Baylog from here on.
I'll do them right now. Thank you, ma'am.
Thank you, Judge.
Hey, boss.
Good afternoon.
Almost done.
Mr. Sarrazin,
Yes,
how are you this afternoon, sir?
good. How are you?
I am wonderful. I have not seen the attorneys from Huron Estates as of yet. We're still early if you sit tight. There's one matter ahead of yours.
Bob, here's your reminder.
Alexa, stop. I will do that. I was trying to mute myself.
You're fine.
Okay.
Bob.
Thank you.
Oh, here's the mute button.
Good afternoon, ma'am.
Hello,
How are you?
I'm okay.
I have not seen a representative from Mr. Levine's office as of yet. When he gets here, we'll get you all together and we'll get going on your matter, okay?
Okay, thank you.
Thank you.
Mhm. This is for Judge Lisa, right?
It is. I am Judge Martin.
Oh, hi, Judge. I'm so sorry. How are you doing?
No worries.
I'll call you Lisa. I'm so sorry.
If that's the worst thing I'm called today, ma'am, I've had a good day.
I know that's right. I'm going to set the phone down, Judge Martin. I'm still here.
Understood. That's fine.
Okay. Yes, ma'am.
Mr. Saracen? There's no smoking in the courtroom. I know it doesn't feel like a courtroom to you, but if you're gonna smoke, you can turn your video off or you can step out.
Okay, I'll step away.
Thank you. Good afternoon, Mr. Barker.
Good afternoon.
We're waiting for the attorney to show up. There's a couple of cases ahead of yours. We'll get to you as soon as we can, sir.
Thank you.
Thank you.
I don't want nobody here on my business.
Now, any other time, Mary Ann, his office would show up early, but not today.
Murphy's Law.
It's fine. Oh, Mr. Pallets too. So whoever comes first will get going.
Oh, who's?
I mean, there's the black shirt and the blazer on your name, please. Yes, ma'am, you. With the finger up, your name, please.
Hi, Holly, AG.
Thank you, ma'am. We're still waiting for the attorney's office to appear. If you sit tight, we'll get to you as soon as we can.
Thank you.
Thank you.
I should be done in a second.
Good afternoon, Mr. Morton.
Good afternoon, Your Honor.
How are you, sir?
Normal day. How are you, Your Honor?
I am wonderful. Miss Patricia Holly is here if you need to speak to her before your case is called.
I would appreciate that very much, Your Honor.
Thank you. Miss Holly, please join Mr. Morton in the breakout room. You'll see an invitation to join him momentarily.
Yes, ma'am. Thank you.
Thank you. Mary Ann, do you have any messages regarding Friday?
Unfortunately, I do not. I know.
Good afternoon, Mr. Morton.
Good afternoon.
How are you, sir?
I'm well. How are you?
I'm good. Mr. Saracen is here. We have not seen anyone from Mr. Levine's office as of yet.
Okay, sounds good.
Thank you.
Thank you.
Do you need to speak to Mr. Saracen?
If I could just speak to him briefly, I would appreciate that.
Marianne will get you into a breakout room with him. Good afternoon, Ms. Kennedy.
Good afternoon.
Mr. Levine. Oh. Good afternoon.
I'm just gonna grab my jacket.
No jackets. What are you talking about?
I can go get it.
Mr. Levine, I was just being, go get your jacket. It's okay.
I'm going to get it. Yeah.
Mr. Morton, was that sufficient time with Ms. Holly?
Yes, Your Honor, the
Yes.
parties have spoken.
This is 215687 LT. This is Rawsonville Woods versus Patricia Holly. May I have your appearances, please?
For the record, Your Honor, Attorney Ian Morton, appellate's law on behalf of Rawsonville Woods.
I'm Patricia Holly.
Thank you. Today is a day and time set for hearing on the plaintiff's request to lift the Sarah stay that went in place on December 29, 2021. 62 days have passed since that stay entered. Mr. Morton, what are we doing this afternoon?
Your Honor, the parties have entered into a proposed conditional dismissal. Rents retained are $5,810.93. Court costs of $164 for a total of $5,974.93. We've agreed to a payment date of 3/21/22, so March 21st, 2022. This will be entered by conditional dismissal. Holly has reapplied and or is having her Sarah amounts, which was initially denied, reconsidered. Was it based on a recent condition? So she's hopeful that those funds should be able to come in before that date as well. And she has given me permission to sign her name to the proposed conditional dismissal, Your Honor.
Ms. Holly, you were able to hear Mr. Morton just now? Ms. Holly,
Yes, I'm sorry.
you were able to hear Mr. Morton just now?
I didn't hear him. I'm so sorry.
That's okay. Mr. Morton has indicated that the parties will sign a conditional dismissal wherein you agree that $5,810.93 in rent is owing. There's $164 in court costs for a total of $5,974.93, and that you will pay this amount on or before March 21st, 2022.
Yes,
Is that what you wish to agree to, ma'am?
yes, yes, Your Honor.
And you've given Mr. Morton permission to sign your name to that conditional dismissal.
Yes, Your Honor.
Do you have any questions, Ms. Holly?
No.
Mr. Morton will sign your name to the conditional dismissal with the terms that were just read into the record. Once I see it, I'll sign it and a copy will be mailed to you. Anything else in this matter, Mr. Morton?
No, Your Honor.
Anything else, Ms. Holly?
No, no, Your Honor.
Thank you, ma'am. Good luck to you. Have a good afternoon.
You too. Thank you. Look.
Mr. Morton, you know the rules. If you want to hang around a little bit longer, I'll call your Williams case shortly.
Absolutely, Your Honor.
Thank you. Mr. Levine, Mr. Barker is here for the Maple Leaf case, 215575 LT, Maple Leaf Gardens versus Todd Barker. What?
Afternoon, Jarrett Levine for the plaintiff.
Mr. Barker, state your name, please, sir.
Todd Barker.
Thank you. Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay. Stay went in place on December 29, 2021. 62 days have passed since that time. How are we proceeding this afternoon, Mr. Levine?
Well, rent remains in arrears and the plaintiff's request is for a possession judgment as the stay has now been lifted. Although I haven't had a chance to speak with Mr. Barker since this request was made. So it might be a good opportunity to go into a breakout room.
Mary Ann will get you into a breakout room.
Would you include Brandy too? Brandy Conway?
Absolutely.
Thank you.
Mr. Morton, where else were you today?
Your Honor, I was at, we have one other matter and that's for Miss Williams.
Where else were you today other than 34th District Court?
Oh, I actually had a matter in Ohio by Zoom as well.
There's someone else here from Pallets.
Yes, Your Honor. Miss Courtney Kennedy, she's a law clerk with our office who recently took the bar, so she's learning and assisting.
Well, she came on with no audio and I just saw the name. I wasn't sure. Thank you.
Absolutely.
She just took the bar.
She's surviving and doing well.
You didn't tell her to run while she can?
We did, but she's a smart person and she feels she's going to be strong and be able to stick it out.
Oh. See, Marianne, the question is whether or not Miss Agee brought enough for everybody. I can't tell.
I know, I was thinking the same thing, Judge.
I've been drinking the same cup of water since 9 o'clock this morning, so. This has been the Monday is Tuesday we've had in a long time.
I completely agree with that, Your Honor.
Miss Kennedy,
Yes,
where'd you go to school, ma'am?
I went to Cooley over in Auburn Hills.
And now you're clerking with Pallets?
Yeah, I've been here about 4-ish months now.
Okay. Where else have you worked during your law school years?
I did an externship at a personal injury firm over in Bloomfield Hills. And then I worked a little bit at a estate planning firm over in Livonia.
How'd you wind up with Pallets?
They kind of found me, and one thing led to another. Here I am.
Matt Pallets has always had great taste and great instincts, so I guess that's a good thing.
We try not to say too much to make his ego too much larger, Your Honor.
Well, I haven't seen him in a number of years, and he and I used to regularly run into each other in 36. That was years and years and years ago.
Well, we thought we were doing you a favor by not having him come into your courtroom.
I think the last time I saw him was in 36. Oh my goodness. Marianne, nobody's ready. I'm trying to. Mr. Williams didn't come out just yet. But Mr. Palace, we're a little, Mr. Moore, we're a little early, but I'm going to release you. I think we've had enough time together today. This is 215697 LT Rawsonville Woods versus Shayla Williams.
Your Honor, for the record, well, make sure I'm not on. Okay, want to make sure I was not on mute. Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Rawsonville Woods. Ms. Williams currently has a past due balance of $5,917.76, core cost of $164, total of $6,081.76. They have not received any funds from Sarah or any update regarding any funding or directly from her. So based on that, we'd ask a default judgment for possession only be entered.
Thank you, sir. This matter was scheduled for 1:15. It's now 1:26 by the court's clock. Shayla Williams or anyone from 271 Rustic Lane, Site 271. Matter was scheduled this afternoon for hearing on plaintiff's request to lift the Sarah stay that went into place back on December 29, 2021. 62 days have passed and plaintiff's attorney indicates that funds have not been received based on the defendant's failure to appear this afternoon and no money's being received from the Sarah program. Default judgment will enter in favor of plaintiff and against defendant with writ to retain possession of $5,917.76. There's court cost of $164 for a total of $6,081.76. Plaintiff's office to submit that default judgment. Anything else in this matter, Mr. Morton?
Nothing else, Your Honor, and I wish the court a wonderful
Thank
rest
you.
of its day.
You
Good luck.
too, and good luck to Ms. Kennedy. Let's get an update when the results come in.
Absolutely.
Thank you. Mr. Hill and Mr. Williams, are we ready to proceed?
Yes, Your Honor.
This is 212498 GC. This is Midland Credit Management versus Jerome Williams.
Yes, Your Honor.
Yes, Your Honor. William Hill, P 28608, appearing on behalf of plaintiff Midland Credit.
And Jerome Williams is present, Your Honor.
Your Honor, we were
Thank
before.
you.
Okay, I'm sorry.
That's okay. Today is the day and time to set for the final pretrial on this matter and hearing on plaintiff's motion to compel. How are we proceeding, Mr. Hill?
Your Honor, interrogatories were sent out. We filed a motion to compel answers to the interrogatories. At the time the motion was filed, we had not received any written responses from Mr. Williams. Subsequently, we did receive some responses from him. However, it appears that the responses do not contain the information that would be helpful to resolve. Mr. Williams may have a bona fide defense to the case, and we have sent him out a dispute letter, and we'd like to hear his story as to his defense as to why he doesn't owe the money on this case. I know it's up for a pretrial. I know it's been pending for a while, but Mr. Williams and I both agree. I've listened to his story in this case, and he's going to provide some documentation to support his claim. The information that he did provide from us would not be a defense to the claim. However, perhaps he can submit an affidavit or some other physical evidence. Both of us think it might be in the best interest of resolution if you could grant us 60 days to discover this thing, to investigate this dispute.
Is that accurate, Mr. Williams?
Well, I feel like I'm at a point where, well, first of all, Your Honor, the last time we was in court, I wasn't,
Mr. Williams.
Yes, ma'am. Yes,
I'm
Your Honor.
sorry. The question was, is it accurate that your conversation with Mr. Hill was to adjourn the
Yes,
matter?
it is accurate. Okay, yes,
Okay.
it is accurate. It's accurate.
Okay.
Is that the way it goes? Can I say something? Or
When I ask a question, I just wanted an answer.
Okay,
because
yes, yes,
You
Your
might
Honor.
not see the other 11 people on the screen, but I
yes,
see them
yes, Your Honor.
respond.
Yes, Your Honor. I'm sorry. Yes, Your Honor.
Okay. No,
Yes.
Mr. Williams, please, no. You say what you want to say. I just wanted.
I just wanted to say that the reason why I agreed to the 60 days is because I'm currently not home, so I don't know what they sent me and asked of me. I did answer the previous questions that they asked, and I thought they were like sufficient enough to get going with this case. But Mr. Hill gave me some more insight as to dealing with this. So I think that'll be the best way to go about it. just so I cover all my bases on this thing as being as upfront with information and trying to do whatever it is I gotta do to prove my point. That's all I wanted to say.
Thank you. The last time we were here was with Mr. Perry on February 1st, 2022, and we had a quite lengthy discussion about what was going to happen in terms of responding to interrogatories.
Right.
Mr. Williams' position has been consistent throughout that there was a issue with the quality of the bid. It took some time to get that addressed, but inasmuch as the parties have agreed to adjourn this matter, the court will adjourn the final pretrial and motion to May 3rd, 2022 at 9 a.m. Anything else, Mr. Hill?
Your Honor, so I understand you correctly. The motion that we had to compel answers would be adjourned to May 3rd, as well as the final pretrial, both of them?
Absolutely, sir.
Okay, because we have sent out a dispute letter to Mr. Williams. I've advised him how to proceed with that, and hopefully we'll have some more information for you. And I'm going to put this down for Midland to appear for both matters on May 3rd. Is that correct, Mr. Williams?
Anything else, Mr.
Yes,
Williams?
yes, sir.
Okay.
Yes, sir. No, Your Honor.
Thank you much. I'll see you both here May 3rd.
What time would that be, Your Honor? What time would that be?
9 a.m.
9 a.m. Thank you.
Thank you, Your
Thank you.
Honor.
Have a good day.
Okay.
All right.
Mr. Levine and Mr. Barker, are we ready to proceed?
Yes, Judge.
Yes.
215575 LT. I already have your appearances noted. Today was a day and time for hearing on plaintiff's request to lift the Sarah stay that went in place back on December 29th. How are we proceeding, Mr. Levine?
Your Honor, we have terms for a proposed consent judgment. May I place the terms on the record?
Absolutely, sir.
The amount of rent to retain is $3,161.98 plus costs of $164.53 for a total of $3,326.51. Parties are agreeing to an extended repayment plan, slight extension under further orders, and this is for possession only. And the parties agree that the defendant shall pay $1,650 by March 11th and $1,761.51 by March 25th. Failure to remit either payment shall cause a writ to issue upon application without further hearing. I read the judgment to Mr. Barker in the breakout room. He indicated his intention to consent and gave me his permission to sign his name.
Mr. Barker, were you able to hear Mr. Levine just now?
Yes.
And you agree that there is rent due and owing of $3,161.98
Yes.
and court costs of $164.53,
Yes.
and that you will pay $1,650 to plaintiff's office on or before March 11th,
Yes.
and then $1,761.51 on or before March 25th, 2022.
Yes.
And you've given Mr. Levine permission to sign your name to the consent judgment.
Yes.
You understand that because Mr. Levine represents Maple Leaf and you are unrepresented, that judgment will not be enforced for a period of 3 days.
Yes.
Mr. Barker, what happened with the Sarah application?
I'm still waiting to hear back for them. They told me they have 90 days to respond. That's as far as I've gotten with them. I still try to contact them as much as I possibly can. I've also filled out applications through DHS for trying to get help and haven't heard anything back.
Mr. Barker, when Mr. Levine signs and submits the consent judgment, the court will sign, a copy will be mailed to you. It might be beneficial to you to submit that to Wayne Metro as well. Maybe that'll stimulate them to get your application processed and resolved, okay?
Okay, thank you.
Anything else before you go, Mr. Barker?
Nope,
Thank you for your patience this afternoon, sir. Have a good day.
you too.
Thank you. Mr. Morton, 215525 LT. This is Huron Estates versus Robert Saracen.
Good morning, Your Honor. Adam Morton, P85423, on behalf of the defendant.
Chair Levine for the plaintiff. Also present is Robert Cost, property manager.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that went in place on December 29th, 2021. 62 days have passed since entry of that stay. Mr. Levine, how are we proceeding this afternoon?
Well, the request is for a possession judgment for non-payment of rent. And I don't know if Mr. Morton has an update on the status of Sarah. We've yet to receive a payment.
I
We're
was,
asking the court to-
I was hoping to speak with you in a breakout room briefly just about that.
We have a breakout room.
Now.
Thank you.
Thank you. Mary, I want to get you into a
Thank you.
breakout room. Mr. Heffernan?
Okay.
Good afternoon, Mr. Heffernan.
Good afternoon to you.
How may I help you, sir?
I guess this is pre-sentencing date or my court date.
Mr. Heffernan, you were due here yesterday at 1:30. You were due here on February 28th
Oh,
at
it was for
1:30. It's
yesterday
March
at 1:30?
1st. Yes, sir.
Oh, it is? Oh, I'm sorry. I've been
was.
taking care of my mom. I didn't even know. Oh, okay. I'm sorry.
Check your notice
I
and
missed
contact the
it.
probation department. They're the ones that need to speak with you, okay?
Okay. Okay.
Do you have their
Yeah,
contact
this is my
information?
first time doing this.
It's okay. You have the
Information?
contact information for the probation department, sir?
Yeah, yes, I do. Yeah.
Okay,
Okay. Okay.
Thank
Thank you very
you.
much. Okay, bye-bye.
bye-bye. The file might be out in the hallway, Mary Ann. I'm
Yeah,
not
I
sure. It
just
says
pulled
it
it
was
up.
on its way upstairs.
Yeah. I
I'm
just
looking at
found
the
it out.
doc, at the ROA, but it says the file came up to me yesterday and I haven't seen it. Or, you know what? That's not true. I think it's on the conference table. Don't worry about it. I'll look at it when I get back from lunch.
Okay.
See, these attorneys trick me, Mary Ann. They say they're going into the breakout room real quick. Are we ready to proceed on Saracen?
Yes.
Yes, Your Honor.
How are we proceeding?
Your Honor, for Saracen, Mr. Morton informed me that there's a Sarah recert in the works. And we'd ask for just a brief adjournment and hopefully have the matter resolved for you before the next hearing. If the court's available in a week.
I am not available in a week. Marianne, I think we're using March 23rd for some reason.
Okay.
Give me 1 second.
I'm checking.
I thought I gave that date to Sandy for something else.
Oh, those are your second hearings.
But I can do it then, right?
Right.
There's no objection. Okay. March 23rd, 2022 at 10 a.m.
Okay, thank you.
Thank you, Your Honor.
Anything else, Mr. Levine?
No, I just asked that Mr. Morton keep me apprised, and as soon as he has some updates on that research, to get it to me.
Yep.
Anything
I
else,
will.
Mr. Morton?
To support it.
Nothing here, Your Honor.
We'll see you here on the 23rd. Thank you.
Thank you.
And then we have Ms. Agee, who has been incredibly patient, 215532 LT, Huron Estates versus Holly Agee.
Hello.
Kurt Levine for the plaintiff. We also have Robert Koss, property manager.
Holly Agee.
Thank you, ma'am. As in the other cases, this case was scheduled this afternoon on plaintiff's request to lift the Sarah stay that went in place on December 29, 2021. 62 days have passed. What is the status of this matter, Mr. Levine?
Rent remains in arrears. Sarah has not, we have not received payment through the Sarah program, and our request is for a possession judgment at this time.
Ms. Agee, have you received an update from Wayne Metro?
Yeah, I spoke to Doreen yesterday and the day before, and they requested some paperwork on the 22nd from Huron Estates, and she said she sent that over. And I requested, they asked me for the full lease agreement, and she also emailed, Doreen also emailed that over for me. So it went into processing on the 22nd. So it did move forward.
Mr. Levine, if you want to, do you need to speak to Mr. Cost regarding these documents that need to be submitted?
Maybe if we could have a breakout room with the three of us, that might be meaningful.
Absolutely, Marianne will get you into a breakout room.
Thank you.
Good afternoon. Could you look at something for me, please? 210810. He just popped into my civil docket a second ago, so I told him to call you immediately and send in the file back downstairs. So long as he contacts you all by 4 o'clock tomorrow, reset his PSI, otherwise I'll sign the bench warrant. Thank you, ma'am. Bye-bye. Back on the record, 215532 LT. How are we proceeding?
Another adjourn, if we could keep this case on track with the other file for March 23rd at 10 a.m. There is a pending Sarah application that we're not quite sure how that's going to play out. We want to give it some time. And Ms. Iggy is also committed to making a good faith payment and has some other plans in mind if it doesn't go through. So we'd ask for the 23rd and hopefully get the Sarah approvals. If not, be before Your Honor asking for a possession judgment that day.
Were you able to hear Mr. Levine just now, Ms. Agee?
Yes, ma'am.
We're adjourned to March 23rd at 10 a.m. Anything else, Mr. Levine?
Nope.
Anything else, ma'am?
That is all.
See you in a couple of weeks. Have a good afternoon.
Thank you, you too.
Thank you.
I'll play it right now.